Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3208 et al. United States of America versus Casey Cusick, appellants. Mr. Roots for the appellant, Mr. Dietrich Hill for the appellee.
Good morning.
Thank you so much, Your Honors. May it please this honorable court. My name is Roger Roots, and I represent the appellants in this case, Mr. James Cusick and Casey Cusick. The Cusicks, I should say they are father and son. James is the father of Casey. They are January 6ers. They are among the hundreds of defendants who've been prosecuted for essentially going inside the U.S. Capitol on January 6, 2021. And I note that this Court of Appeals has addressed a couple very, very similar cases. In particular, these are cases involving what we call the four standard misdemeanors. Hundreds of people have been prosecuted for these four standard misdemeanors. Count one is always entering and remaining in a restricted area. Count two is disorderly conduct in a restricted area. Count three is always, it involves the statutes relating to the U.S. Capitol. So disorderly conduct inside the U.S. Capitol. And then there's count four, which is picketing and or parading inside the U.S. Capitol. This Court of Appeals has previously dealt with two very similar cases that I want to point out. First, the Nassif case. The Nassif case was essentially a First Amendment challenge to count four, and that's that picketing and parading statute. The Court of Appeals upheld Nassif's conviction. Then there was the Alford case, also involved the four standard misdemeanors. Alford challenged variations of what has become known as the raindrop theory, the idea that disorderly conduct can be simply being inside the Capitol without doing much more. In this case, the Cusick case, I submit, involves the most innocent people yet. In other words, the Cusicks, unlike Alford and unlike Nassif, did even less than either Nassif or Alford. Alford didn't do much, but he did trigger an alarm. He did try to push open a door, things like that. Nassif, of course, did chant and he made noise and shouted and things. So
Can
the
I
key,
confirm with you, your argument is a challenge to the sufficiency of the indictment, not a challenge to the sufficiency of the evidence. Is that right?
I believe we're challenging both.
Well, your brief seems to challenge the indictment. It refers to the indictment as the, I'm sorry, it keeps referring to Judge Bates's opinion that denied the pretrial motion that said that there was insufficient probable cause to support the indictment.
Yes, yes.
And so if you're challenging the sufficiency of the indictment, these arguments that you're making now are not really relevant.
Well, we're making a number of challenges, obviously.
Where is your sufficiency of the evidence argument in your opening brief?
It's in there. We don't emphasize
I don't want
that.
emphasis, just tell me where it is. You don't have to emphasize it.
Well, I do know that we bring that up. Let me just see here. Let me just see if I can. I guess at heart, I could sum up that we're making a couple of different challenges to several issues.
Have the First Amendment claims, we're clear on. You clearly have the First Amendment claims.
Yes.
Got that. And the other one, I had read your brief the same way as Judge Pan, and that was that you were challenging the information in this case. And the district, in particular, district court's refusal to dismiss based on your argument that the information was insufficient to state criminal count against your clients. Is that understanding correct?
Yes, we do make that challenge.
Okay.
In this way, the Cusicks were accused of committing these 4 crimes essentially by being there. And that goes to the heart of all that we know about criminal prosecutions. No, the most fundamental jury instruction in every jury trial is an instruction that says that an individual must be judged.
But a challenge to the sufficiency of the information, thank you, it's an information, not an indictment. It's the charging document. And the charging document in this case just laid out what they allegedly did on those days by mostly using the statutory language. And there's precedent saying that that's a sufficient information. That's a sufficient charging document. So if you're challenging the charging document, it's a different analysis from what you're making at the podium. We're just looking at what does the information say, and is it sufficient to put the defendant on notice of what the charges are? And the information in this case is very consistent with others that we have upheld in the past.
Sure. I'll just say that in this case, there's an overarching First Amendment aspect to this. This was at the U.S. Capitol where the U.S. Congress is meeting.
I understand your First Amendment claim we can discuss, and I think we can, but just focusing first on your theory about the raindrop theory, that seems to me to be a challenge to the sufficiency of the evidence at the trial. It's not a challenge to the sufficiency of the information, which is what you're making.
Sure, yeah. I would say the information, though, was worded in such a way that it would apply to completely innocent behavior, which cannot be a crime. And so that was the basis of that challenge.
Well, the information just charges the defendants with knowingly and with intent to impede and disrupt the orderly conduct of the government business, et cetera, for engaging in disorderly and disruptive conduct. It alleges what the government thinks they did. And that is not innocent conduct, is it?
No, it's not. But let me just say that in the context of the entire information, it has to be read with this notion that essentially they were committing these crimes by being there.
Well, by being somewhere that they were not lawfully allowed to be. I think that's, we have to start with that. We can't just say they were just there. They were there where they were not lawfully authorized to be. So that's not perfectly innocent conduct.
Sure. Let's put it this way.
We agree that they were not lawfully authorized to be there, do we not?
I believe they, certainly the evidence did not substantiate that. This goes to the sufficiency.
Right.
The evidence didn't substantiate what?
It did not substantiate that they were notified properly that they weren't supposed to be there.
Oh, really? When they see people pushing past lines of officers, when they see pepper spray and fencing and everything else pushed down, there wasn't sufficient evidence for a rational jury taking everything in the light most favorable to the government to reasonably find that there was evidence that they weren't supposed to be there. That's your argument?
The evidence was very clear. Jim and Casey Cusick walked through an open door. They essentially were following the crowd. They had interest in what the crowd was doing.
They went past 2 area closed signs and by officers in riot gear and toppled barricades. That was the evidence.
Would that not alert a reasonable person that perhaps they're not supposed to be there?
There's a lot of video in this, and it did not show that they walked past or through. They did not pass a barrier that was directly in front
There
of
was
them.
evidence that they went past barriers. They went past toppled barricades, that broken glass, alarms going off, and officers fighting against protesters. And so I guess I'm struggling. I can't speak for my colleagues. We're struggling with how that was not evidence that they were in a place they were not supposed to be.
I have to confess, the memory of the trial is over a year ago, but I don't believe there was evidence that these particular appellants saw fighting with officers.
There's evidence that one of your clients made a remark, we need to hurry up because I don't want to get hit in the head by a billy club. Remember that evidence?
I don't really remember that. I do recall some statements sort of, hey, there's some pepper spray. I believe Casey
Another good
Cusick.
sign that they're in a place they're not supposed to be then.
Well, it's certainly evidence of something. Let's put it this way. It can be.
No, it's not evidence of something. It's whether a reasonable jury could conclude that that's evidence that they knew they were someplace they weren't supposed to be.
Well, is that the case? If I see pepper spray over here, does that mean that I know I'm not supposed to be here?
Pepper spray's going off. If you're afraid of getting hit in the head at Billy Club, if you hear alarms going off, I mean, we can't suspend reality here.
Sure.
We don't sort of just look at these two and ignore all the evidence around them. We don't expect a jury to do that. A jury might be able to do that, but the jury didn't do that in this case.
Well,
So even assuming you have raised a sufficiency of evidence challenge, what's your best case that is not sufficient?
I submit that these two appellants are thus far the most innocent that have come before this Court of Appeals.
Well, they may be, less obviously guilty, may be the better phrase, but that doesn't mean that they aren't guilty of being somewhere they weren't supposed to be. You're not innocent if you're somewhere you're not. If you were to come up here right now and stand up here at the dais, right over me, looming over me, you could be perfectly innocent. You wouldn't break anything, not steal anything. You wouldn't even raise your voice, but you would be where you're not supposed to be, correct?
Sure.
You would be
Yes.
where you're not supposed to be. And
Correct.
you know that you're not supposed to be there. And that would
Well-
be disruptive to my work, would it not?
Of course.
Okay.
But let me just say, in a setting where 100 other people have already done this in front of me, it becomes less clear whether or not it's a restricted
Whether
area
you're
properly.
supposed to be
Sir,
there.
Sir, there was evidence that they were there for a long period of time before they went in, right? At
Yes,
the Capitol.
yes, on the Capitol grounds area.
So they saw that how the people got in was that they overpowered the police. And then they got in, and then they went in. So to just act like they walked in, because everybody else was walking in and they didn't know that they weren't supposed to be there, et cetera, et cetera. They went in after they saw a mob push past the police and go in, and then they're like, okay, we're going to go in too. That's what a reasonable jury could find based on the evidence. And that's not consistent with innocent conduct or not violating this statute. It's consistent with violating the statute. Tell me why it isn't, if that's the evidence that
Well,
the jury could have found.
Let's put it this way. I believe the evidence in this case was that the Cusicks were way down lower at the time. The doors up above were breached. It was hundreds of yards away. So they did not really see how that happened. They did ultimately walk through an open door. They were inside the Capitol building for about 10 minutes.
So it would have been unreasonable for the jury to find that they knew that there was fighting going on and pushing past the police, based on what the jury was told here.
I don't believe there's any evidence that they saw any fighting. I don't believe that came into the trial in this case. I'd have to rack my brain a little bit, but I just don't recall
Is there
any.
evidence that there were alarms going off?
Sure, there were alarms going
That they
off.
heard?
I believe so.
Yeah.
Yeah.
Okay. Is there evidence of broken glass?
Yes.
Evidence
Yes.
of broken doors?
I think perhaps. But I believe Jim Cusick took the witness stand and testified that his understanding was, it was a chaotic moment in time and that there was a lot of things going on, and that the officers that they did see were not saying, get out, go away. In fact, there was some testimony that officers were fist bumping members of the crowd, et cetera. So it was a chaotic situation.
What's the standard of our review on sufficiency of the evidence? How are we supposed to look at the evidence?
Well, obviously, you would look at the case in the light of the government, in the light most favorable to the government's.
The jury didn't have to credit a word of your client's testimony, right?
That is correct. I see that my time is expired, but I would say that this falls under that Adderley. We cite the Tinker case, the Supreme Court case from 1969, and the Adderley case, where a legislative capital is assumed to have more First Amendment protection than other places. Of course, Tinker involved a public school. Adderley involved the grounds of a jail, where these places are not known as public forums for free speech. All of that law says that legislative capitals are the fundamental reason for their existence. And so it has to be, I think, we have to recognize the give and take of that situation, that the U.S. Capitol is a place where people come to confront, to protest, to angrily, perhaps at times, let their voices be heard.
Well, I think the distinction is between the Capitol grounds and inside the Capitol building when there are legislative proceedings underway. I mean, I assume you would agree that the public can't routinely walk in while Congress is trying to vote on measures and yell everything down and
Sure, yes.
prevent business from going. I mean, it is,
Yeah.
to your client's credit, they didn't, at least on this record, as far as we know, break things or hurt anybody. That's to their credit and reflected in the charges and the sentence. But it remains that the inside, I think the difference is the inside the Capitol versus Capitol grounds. I mean, do you have a case that says inside the Capitol, while legislative, maybe any time, but even certainly while legislative business is underway, it's a public forum inside?
Yeah, and I think most people intuitively recognize that distinction. In the case of January 6th.
The charge here is with what they did inside the Capitol, not outside.
Yes, especially with regard to the counts 3 and 4, yes. But I would say in the case of January 6th.
Your First Amendment claim, that's what I'm talking about here.
Yeah, obviously there are greater First Amendment, there's a lot of case law, a lot of First Amendment rights outside, not so much inside. But in January 6th, it was a unique situation. There was a lot going on. There was a lot of chaos where I submit these boundaries were not that clear. People were going in and out.
Crowd's behavior can turn a non-public forum into a public forum. Is that your First Amendment argument?
I actually think so.
If they were confused as to whether it was a public forum, that creates a First Amendment right? I'm just trying to understand then what your point is.
I would say the confusion certainly, it's like
a case that allows confusion to take something that's not a public forum and make it a public forum, confusion by the speaker.
I'd have to think about that.
You can imagine the consequences of a doctrine like that.
Well, I think this is everyday life. Basketball games, NCAA championship games at the end, where the first few people that jump onto the floor, the crowd, they're doing something wrong. But the second 100 people Not so much. And frankly, it becomes, after a while, it becomes an unrestricted area. The referees
Three wrongs
themselves,
make a right.
the referees themselves
No, what-
surrender
no,
the.
Really, it's less wrong. I mean, if something's wrong, it's wrong. Whether 10 people, I thought we lived in a country where if you did something wrong and illegal, the fact that 5 people did it in front of you, or even 100 people did it before you, doesn't suddenly make it legal. Is that your
Well,
argument?
It's a little bit like property rights, easements. There can be an easement in time. A trail
No
becomes.
easement on the Capitol, inside the Capitol, full stop.
Thank you so much.
No, but your argument was it wasn't wrong anymore. Is that your argument?
When the referees cede the field, they are essentially making it a
Not the referee's
non-restricted
field, They
area.
don't own it.
Well,
Sir,
wanna
there's
talk
a
about that.
difference between seating and saying, oh, it's okay for you to be here, and moving aside because you've been overpowered, and the only way to stop would be to use deadly force or to escalate matters where beyond what, might be deemed, sufficient or appropriate in the circumstance. We're
Sure.
ceding some time to you beyond the 10 minutes you get. Doesn't mean that you
have a right.
have a right to speak more than 10 minutes, but we're giving you more than 10 minutes.
They're very, very good example. I would submit that January 6th was such a unique event that there was this sort of almost a popular sovereignty moment where the crowd was so large that the authorities, such as they were, did sort of, for those moments, unrestricted. I thank you so
Any
much.
questions? Thank you very much. We'll give you a couple of minutes for rebuttal.
May it please the court, Teacher Kale on behalf of the United States. The defendants did forfeit their sufficiency argument. But if the court reaches it, this case is not distinguishable from Alford. There was more than sufficient evidence for a rational jury to conclude that the defendant's conduct was disorderly and disruptive when they entered the Capitol grounds and joined this disruptive mob, magnifying its disruptiveness and increasing chaos within the Capitol, which is what this court held in Alford is more than sufficient for a jury to conclude constitutes disorderly and disruptive conduct.
What conduct did they engage in beyond entering and remaining? You have a separate count already for entering and remaining. And then we're going to say, was there any what is the factual addition in their behavior that makes it disruptive?
To be honest, Your Honor, I don't think there is much more, but in this context, entering and remaining as part of this mob, increasing the numbers of the mob, making it more difficult for Congress to continue its work. Congress, which had
But
already,
even if they were the only 2 people who entered and remained and had to be removed before Congress could resume. So if there were no mob, it was just the 2 of them, would you agree that you could also charge disruptive conduct?
Your Honor, I think it would be a jury question. And in
No,
that
but I'm
case,
not asking, I'm asking as a matter of law, do you have another element that makes it disruptive conduct? Because I assume you would have the same argument, they have to be removed before Congress could resume its work.
I don't think as a matter of law, we would need more. It's possible that would also constitute disruptive or disorderly conduct. But again, I think the evidence would be much weaker, but it would still be a jury question as to whether that constituted disruptive or disorderly conduct under all the circumstances. Of course, that's not the case we have. As Alford held, the jury is entitled to look at all of the circumstances, which here made this entering and remaining
It
fundamentally.
seems like at some level, this may be sort of double counting on the enter and remain. And you don't have any other conduct.
I think
I
this,
don't think you even had evidence that they yelled at anybody.
no, there was some yelling, certainly on the grounds that's recorded on their videos, but
That's not relevant to the
no. Or at least not to the 5104. It could be relevant to the 1752, which is in the restricted area.
Mhm.
But no, frankly, as the defendant's counsel suggested, these defendants are relatively low on the scale of disruptive conduct, but so was Alford. And what this court held is it may be the same conduct, but context matters. You don't need different conduct if it violates both statutes. With respect to the First Amendment claim, this court had public forum, and the government therefore has substantial latitude to regulate. In Nassif, this court upheld a regulation that prohibited all demonstrating, picketing, and parading, acknowledging that that was somewhat over-inclusive, that would prohibit some conduct that was not inherently disruptive to Congress. But the court said, in a non-public forum like the Capitol, you don't need the most narrowly tailored regulation that's acceptable. This regulation is more narrowly tailored than that. So almost a fortiori, it is a reasonable regulation. It prohibits only actually disruptive and actually disorderly conduct. With respect to their reply, I would just say that their intent argument is doubly forfeited. There's no sufficiency argument properly presented in the opening brief and nothing about intent. So there's certainly no reason for this court to reach that, which is presented only in the reply. And with respect to Adderley, that's a case in which the Supreme Court rejected the First Amendment claim and upheld the conviction of the protesters. And as Your Honor suggested, the Supreme Court suggested that perhaps state legislative grounds would be a public forum under which different rules might apply. Everybody agrees that the U.S. Capitol grounds are also a public forum, but that's not what we have here on this as-applied First Amendment challenge to conduct within the Capitol.
And it's clear that none of the charges pertain to what they did outside the Capitol building, outside the building.
Well, certainly with respect to the First Amendment challenge, we look at as applied to their conduct, all of their conduct, including their conduct within the building. I hesitate only because I think the jury could have concluded, even based on their conduct outside the building, that they had violated the statute, but they certainly didn't need to look at that because of their conduct within the building.
Why would the jury under the First Amendment be allowed to consider what they said outside the building?
There would be a different analysis as to whether the First Amendment protected the conduct outside the building, which is in a public forum. The government would have to meet a higher degree of scrutiny. But that's, again, I would say this is an as-applied challenge to their conduct within the building.
Did the jury instructions permit the jury to consider acts that occurred outside of the Capitol building to be part of the actus reus, the body of the crime?
I don't recall, Your Honor. I believe it did, but I can't say for sure.
I mean, if it did,
What's the crime?
wouldn't that be a problem?
Not for the 1752 charges, which apply to the entire restricted area.
What is it relevant to?
Excuse me?
What, I'm confused as to what their conduct outside the Capitol building, what charge you think that was relevant to? Because I had understood all these charges to pertain to their entry and presence inside the Capitol building. Am I wrong about that?
The 1752 charges could also be supported anywhere within the restricted area, which included the immediate perimeter of the Capitol grounds.
Okay, all right. I'm sorry, you're not talking about marching up to the Capitol or anything like that, or before they came to the restricted area?
Right, no,
Okay.
that's right. If there are no further questions, we would ask the government to affirm.
Thank you. Mr. Roots, we'll give you 2 minutes.
Yeah, thank you, Your Honor. We pointed out in our brief the Tinker decision, which the government argues is not relevant. It directly involves a claim of disorderly conduct in a place that all people admit is not a traditional public forum for free
A place
speech.
where those students were lawfully, not only lawfully allowed, but probably lawfully required to be.
Exactly.
Right, and that's the difference here. Your speech was in a place that it was unlawful for them to be, and a jury could and did find that they were aware that they were not lawfully allowed to be there. So that, I don't know what to do. I don't see how Tinker.
Well, Tinker involved conduct similar to the conduct in this case, which is standing in a place,
No,
walking.
standing in a place you're not allowed to be is very different from standing or wearing an arm badge in a place you are allowed to be. I mean, the point here is that it was their presence that was unlawful. No one argued about that in Tinker.
Yes, you're correct. I will say that the application to this case is that a public school is a very controlled setting, just as in the interior halls of the Capitol are, and there has to be maintenance of control. But the Supreme Court looked at the wearing of an armband and said, well, it has to be a substantial disruption to qualify as disorderly conduct or whatnot. And it's similar to our case where the Cusicks.
They had prevented the teacher from teaching, that would have been different in Tinker. If the conduct had prevented the teachers from teaching.
Sure.
Okay.
Yeah. In this case, the Cusicks arrived after Congress had long ago,
Questions?
recessed. I
Thank you
thank you very
Counsel.
much. Thank you so
The
much.
case is submitted.
Case number 23-5273, Matthew J. Hight, appellant versus United States Department of Homeland Security et al. Mr. Redfern for the appellate, Mr. Dos Santos for the appellees, and Mr. Longstreth for the intervener.
Morning, Counsel.
Good morning, Your Honor. May it please the court. I'm Jeffrey Redfern here on behalf of the appellant, Captain Matthew Hight. Under this court's APA precedents, the Coast Guard is required to explain the inconsistent treatment of regulated parties. It's required to rationally respond to parties' arguments, and it cannot simply rubber stamp the assertions of third parties. The decision in this case falls well short of those standards. It's not a particularly close call. And I'd like to start by addressing the training. Captain Hight has maintained from 2018 until the present that he did all of the training that he was asked to do, and it's the same training that all of his contemporaries did. They all got their registrations, yet he didn't. And now he's being subjected to a new unwritten requirement that was invented out of thin air for the specific purpose of denying him his registration. Now, under this court's decision in Baltimore Gas, once a party raises credible allegations of inconsistent treatment, the burden is on the agency to explain that treatment. The Coast Guard didn't do that. It said, I'm not going to discuss the status of another mariner, and even the final decision in this case doesn't even acknowledge these allegations. It just says you haven't completed your training because the association says so.
No, it doesn't say that, sir. You look at J271, the decision on appeal, the director said, while Captain Hight has adequate lake experience, he has comparatively little river experience and has never solo navigated a vessel between Snell Lock to the east and Cape Vincent, where D1's waters become undesignated, right?
That's correct, but that is simply repeating what the association has told the Coast
The
Guard.
question is whether there's substantial evidence to support that finding.
Respect,
Right? Isn't that our standard of review?
Respectfully, no, Your Honor. That's a secondary question. The first question is whether the decision here has adequately explained inconsistent treatment.
Well, you say it's inconsistent treatment. What evidence is there in the record that other people were treated inconsistently other than Ipsy Dixit?
So, two, Your Honor. First, the association's own articles make quite clear that this river training is not a prerequisite for full registration. That has not been explained by the Coast Guard or by the association. Second, under Baltimore Gas, my client doesn't need evidence. He just needs credible allegations, and then the agency has to respond. And what my client has been saying since the beginning is, look,
So wait, you say, so what about JA 135, deputy pilot training phase? This is the association's training program. Point 2, during the deputy pilot training phase, the applicant pilot will work alone, usually alone in undesignated waters, but will continue to make trips in the designated waters of the piloted district in the company of registered pilots. This is their training plan, and it says the deputy pilot training phase includes continuing to make trips, plural, in the designated waters of the pilotage district. You said it's not written anywhere. Why is that not it?
well, the specific number of trips are
I
not
want that
written.
number of trips.
Yes.
You said it wasn't written anywhere. Right here it says you're supposed to make trips, plural, in the designated waters. And there was a finding that he has never solo navigated a vessel between, just for shorthand, in the designated waters. So your answer was it's not in their plan. It's right here in their training
So-
plan. And the fighting about is right there.
Your Honor, my client has maintained from the very beginning that he did exactly what he was told to do, just like every other pilot did.
What's written down right here.
He did take-
copy
he
of
did
his
take-
training plan? Or no?
Yes, he has a copy, and he
Okay.
did do additional trips when he was told to do them, just like he said every other pilot did. What he asked the Coast Guard to do was just look at the records of his contemporaries. He said, if
He
you,
didn't have any evidence. He said, just look at pilots, and he gave like a bunch of numbers that included himself. That's not evidence. Go look at these records. That's
he
not evidence.
doesn't, Your Honor, he doesn't have access to those. The
Okay,
Coast
then
Guard
how
wouldn't
does he
give
know
him.
anybody had the same record as
Because,
him?
Your Honor, because they're his contemporaries, and he knows, they told him.
No.
and-
Did he have affidavits from them?
No, he didn't, Your Honor.
Not. He
Your-
didn't have evidence of any differential.
Your Honor, the standard under Baltimore,
Time out. Somebody just saying, I think my friends are treated differently from me is not going to undercut substantial evidence when you have written words of requirement and a factual finding that is not disputed of a requirement. Just saying, oh, someone told me that they didn't have the same thing. Should have gotten an affidavit from him.
well, he has his own affidavit, Your Honor.
Yeah,
And
that doesn't tell us anything about, to make a differential treatment claim. That tells us about his, and that's relevant for that. That does not evidence a differential treatment claim.
Your Honor, determining whether he's correct is very easy because the Coast Guard is supposed to have these records.
Very easy if he comes forward with declarations from these buddies of his who he says all told him that they were treated the same way, same as him and had the same requirements as him. What prevented him from doing that?
Your Honor, the problem is that the Coast Guard never gave any response to
Because
this
there wasn't
allegation.
any evidence.
Your Honor, the Coast Guard never told my client that come back with evidence
That's
and
not
then,
that's not how administrative proceedings work. There's no trial judge that says come back with evidence. He sought a hearing and he had a burden to make a demonstration if he wanted to assert deferential treatment. That's a burden on him. And that burden is not substantiated by going, well, I think I heard that from my friends that they were treated differently,
Your Honor,
when he
He-
could have gotten the information. Nothing stopped him from getting the information.
what the Coast Guard told him when he said everyone else has been treated differently is, I'm not going to discuss the status of another mariner. Coast Guard never said,
Mhm.
we don't think you're right.
Well, for privacy reasons, they're not going to start hauling out records on other people and putting them on the public record when there hasn't
But-
been any evidence of differential treatment.
Your Honor, that's what the APA requires. At the very least, the Coast Guard
Requires
needed to,
agencies to rebut arguments that are not substantiated.
Your Honor, these are very detailed allegations and Baltimore
This is
Gas.
not my point is that the differential treatment one was not detailed in the least. It was an assertion that was completely unsubstantiated.
Your Honor, there's a declaration that details this, JA 253 through 59.
Whose declaration?
That's Captain Hight's declaration. The Coast Guard has this.
Mhm.
And he explained the way river training worked is that once pilots were advanced to the deputy phase, they were dispatched. They don't have control over where they go. They go where they're told to go. And he went on the lake the majority of this time. And the way training has always worked is that after pilots get their full registration, then they do these additional river trips.
That's what he said.
Yes,
And then the training association said, no, here's our training plan
right.
and this is what we do. And then he come back and said, no, it's not, but I have no evidence. I mean,
But-
he is not in charge of the plan. He's one person, he's a student going through it. And he doesn't get to declare what the plan is without evidence other than his own say-so, his own thoughts about this. If he had evidence from other pilots or pilot trainees, he should have come forward with that. Was correct?
No, Your Honor.
No.
No one has ever, the standard is credible allegations. The standard is not that you have to prove inconsistent treatment. And I also think that this court's decision in NTE Connecticut is relevant here because this court has held repeatedly that when you have two competing factual assertions, the agency cannot simply say, well, we're siding with this one without providing an
have-
explanation.
Factual assertions, that is evidence. What, if you have a case where we have said, when someone just asserts something without any evidence, the agency decision is overturned when the agency points to its own evidence, the evidence before it that says the otherwise, what would that case be?
Your Honor, I think that's NTE gas. You had,
No substantiated evidence,
so
no affidavit, no
I think-
declaration, no piece of paper.
what I think is inexcusable in this case, Your Honor, I think this is actually significantly worse than NTE gas. There you had two private parties who are making competing assertions about what's likely to happen in the future. That's an inherently uncertain enterprise. Here we have competing assertions about a state of facts in the world that it is incredibly easy for the Coast Guard to figure out the truth. All they have to do is look
They
at
said
records.
We looked at the training plan and it's quite explicit. Okay, that was their answer. The training plan says this.
That's not what the Coast Guard said, Your Honor.
That's what the decision says.
No, Your Honor, the Coast Guard said that the association is resolute that you have not done enough work on the river to demonstrate proficiency. My client's contention, which was not
That
rejected,
expired for full registration on all waters of the district.
and he did not,
No evidence that he's done what what the plan says he's supposed to do.
and Your Honor, the decision wasn't responsive to his argument. He didn't say that I've done all of these river trips, which historically have always been done after full registration. He said that everyone else before me did their river trips after they got registration, and it should be the work of an hour for the Coast Guard to just look at the records.
You
They-
seem to be proposing a standard that if anybody just raises a possibility, then the Coast Guard has to go and research it and prove whether it's correct or not. That's just not the way it works. You conceded there has to be a credible allegation. And
Absolutely.
there's no credible allegation if there's no evidence whatsoever to support the contention.
Well, Your Honor, his own affidavit, his own detailed allegations, I mean, we consider allegations credible in the context of a complaint where,
But where the allegation is about disparate treatment
Mhm.
involving other people, there has to be some evidence about how the other people were treated. You can't just say it's a possibility and ask the Coast Guard to figure it out for you. You have to have
So-
evidence.
Your Honor,
And it seems to me that the one person that was specifically referenced, Chris Wegler, your client seemed to concede that he had to do additional trips before he was registered.
only after my client pointed out the inconsistent treatment.
But there's no inconsistent treatment, in other words, though.
Well,
There
but
is
my-
none.
but the
There's no
inconsist-
evidence even with respect to the one person that.
No, Your Honor, the inconsistency is that my client was not allowed to do those trips. If this were really about the training issue, then they would have said, oh, you're right, you
Wait,
haven't
wait,
done
wait.
these trips.
That's a whole different claim. So now you're saying that what was arbitrary and capricious is that the Coast Guard should have forced the association to let him do some trips on the designated waters? Is that your claim now? Because that's not the claim that was pressed below, or that I even see really being pressed administratively.
So I mean, we've certainly made the point that if the problem is that he has to take trips that he cannot take because the association won't let him, that's certainly preserved. That's the essence of our First Amendment claim. And the Coast Guard knew
Where
this.
in the record did you argue that he wasn't allowed to take the trips on the designated waters that were supervised?
He asked to and wasn't allowed to.
So in his communications with the Coast Guard all throughout 2018, whenever the Coast Guard told him, you have to take this up with your association, he said, the association isn't answering my calls. They won't talk to me. They don't
Where
answer
in
my
the record
emails.
did he argue that I couldn't have taken these designated trips that were supervised? Because that, when he was told, you're out of the program, they said, look, you haven't completed your training and you have a temperament issue. Where did he say, well, I couldn't have taken those trips because you didn't let me? I don't see that in the record.
Well, just one correction. At no point when he was dealing with the Coast Guard through 2018, did they ever say you're out of the program because of the temperament issue? What the Coast Guard kept saying was that you have to work this out with the association. I've counted about 10 places in the JA where
I thought there was a letter on, this was March 17th. It was like he responded.
I think it was March 18th.
March
I believe,
18th,
yes.
and he responded the next day. But I thought that letter kind of explained to him, you haven't completed your training, you have some temperament issues. And then when he responded, he responded the very next day. He didn't say, hey, I wasn't able to complete my training in designated waters because you didn't allow me to. That, I just don't see that as
So I think
part of
this
the
is
arguments that were made.
On JA 159, I believe it is, this is where he provides his story to the Coast Guard.
Yes.
Now, crucially, the Coast Guard here never asked him his side of the story. When the association said, look, we're going to terminate him, the Coast Guard said, we concur about 90 minutes later and never reached out to Captain Hight to ask.
Not true. They kept, there were many communications where they said, give us your information, give us your evidence. They asked for it.
Well, this was
Yeah.
after he reached out to them several weeks later.
Before the final agency decision in this case.
Um,
That's what we were.
yes,
He was told, give us your information, give us your record. If you have evidence, give it to us.
yes, and he provided his training records, which, according to the Coast Guard's initial interpretation, satisfied the regulatory requirements. Then the Coast Guard reinterpreted the regulation at the request of the association so that his trips would no longer qualify. And that's what ended up getting decided in Hight 1. This is really the same issue that we've been fighting about for 5 or 6 years at this point. He provided everything that they requested. And I think at bottom, the real issue here is that there is nothing that he can do to prove the inconsistent treatment because all the cards are in the Coast Guard's hand. He tried to get these records.
Talk to his friends and get an affidavit. I mean, if we were at summary judgment in a civil case in the district court and someone said, well, I have my allegations in the complaint of how other people were treated, but I don't have any evidence yet. That might be enough to get you to pass a motion to dismiss, but clearly would not be enough for summary judgment. Right?
I agree, Your Honor.
So to obtain relief on a petition for review, conclusive relief, you have to meet a summary judgment standard of evidence, right? So his allegations here in a affidavit rather than a complaint are not enough alone if there's not evidence that someone could credit of differential treatment. He needed summary judgment type
And
evidence.
Your Honor, if this were summary judgment, then he would have those documents. He tried to get them in Hight 1 and the Coast Guard said, absolutely not, you can't see them.
No, because there's not discovery you come in on a petition for review. There's no discovery in this court.
Right.
You come in with your story. Now, either you get your evidence and have it, or you don't. This isn't a claim about getting discovery or not. It's a petition for review from a final agency decision that comes directly to this court. There is no discovery, there's an administrative record. And so he either puts information into the administrative record or he does not. And if there's no facts there to substantiate differential claim, we have no way of knowing other than what the administrative record shows. And we see in this record, the Coast Guard saying, give us what information you have. And he never, what you say would only take the Coast Guard a little bit of time, would only have taken him a little bit of time to get some declarations from his friends.
Your Honor, he can't get declarations from his friends because they want to keep their registrations and they don't want to run afoul of the association.
Where's that? And where's that evidence in the record?
Well, he's talked, in his declaration, and in his complaint, he explains that he has seen people retaliated against
His
before.
complaint isn't part of this case because we are in administrative review. All right, so in his declarations
It is in his declaration, Your Honor.
that
That,
tried to get declarations from my friends about their training, but they wouldn't do it because they were afraid of retaliation. Please show me what that page is.
no, there's, the declaration says that he has seen retaliation before and
That doesn't mean he didn't even try? Is there evidence that he tried to get declarations from?
No, Your Honor.
Reference? Okay, then
But-
that's a very different
So I
situation.
think,
So he doesn't have the evidence you need.
Your Honor, what's missing in there, I understand the perspective, and I think what's missing to make that argument work is that there is no place in the record where the Coast Guard said, you haven't shown us that this is true. Show us something. What the Coast Guard said was basically, we don't care. This is all between you and the association. It is not our job. And there is also documentary record evidence showing that, or at least strongly suggesting, that my client is correct. The association's articles say that the river training is something that is not a prerequisite for full registration. That has not been explained. And
Where does that, where
Where are
does
you
it say
reading?
that?
that is at JA 143. It describes a river training plan which will be offered in order of seniority, including to fully registered pilots who are working on the lake. Now, it's possible at JA 143, it is possible for somebody who's not yet fully registered to do the river training plan, but only if everyone with more seniority than them, including fully registered pilots, has done that training. That's the training that they're talking about here. So it cannot be, according to their own documents, a prerequisite for full registration.
Was he an associate member when he got his deputy pilot?
That's correct.
Okay, so unless the program has first been offered to associate members.
That's right. But it says that full members who haven't done the training yet, meaning that it is possible to become a full member, a registered pilot, without having done the training, they get to do it first. So it's descending order of seniority, and that includes fully registered pilots.
But then again, we're missing the point where he said, we don't have evidence that he tried, this is what Judge Pan asked you about, that he tried to get it and they said, no, you can't have it, this training.
Well, we have evidence. He didn't even ask the Coast Guard to see the records of the other pilots. All he asked the Coast Guard to do was look itself. He said, look, these are records you're supposed to have. You can just look. This is the work of a few hours of the other pilots.
Right.
That's
He said,
correct.
just go look at other records. I don't have any idea what they show. And that shows us.
Well, he knows because he's been in this program working with these people for years. So he knows the way it works. But he's saying the Coast Guard can figure out, can prove it very easily. But the cards are all in the Coast Guard's hand. And it can't be rational decision-making to say, look, you have a very detailed allegation here, but the only way you can prove it's true is if we open our own files and take a look. And you know what? We just don't feel like doing that. When a party comes forward with these kinds of allegations, and there is a factual dispute between two third parties, the answer cannot be, under NT Connecticut, that, well, our position is that this party is always right and you are always wrong. They have, particularly when one of the parties says, look, there is a very easy way to determine who's correct, and the agency just says, we don't want to do it.
I just want to note the thing that you were pointing to at JA 143, that's for associate members who are registered for the lake portion. So they're not people who have been already registered for the.
Correct. The way it has always
River.
worked, yes. And the way it has always worked is that people get a full registration and then they go on the lake pool. And then as they work their way up in seniority, then they get moved over to the river pool. But fully registered pilots were working full-time on the lake, having not yet done the river training that the Coast
They were
Guard.
registered for the lake, not for the river.
That's correct.
Well,
Well,
I don't see how that proves your point. You said that this proves that people could be registered without their river training. He was trying to be registered for both the lake and the river.
no,
Without
you're-
having the appropriate river training.
no, Your Honor. He wants a full registration, which has always been offered initially just for the lake. And he would be happy to have that because that would
Not my
let him work.
understanding of how it works, based on this record.
Well, based on his, he explains this in a lot of detail on JA 253 through 59. This is how the training has always worked. And he just wants to go to the next step where he gets to work full-time on the lake. And then, the river training, we might have to have a fight about whether he gets to do
doesn't
that.
get to explain how registration works. The laws and regulations dictate how registration works. What law or regulation says that you can be fully registered just for the lake and it's irrelevant whether you have registration for the river and be fully registered, which is what your client request.
That's not in the regs, but it is past practice, and there's documentary evidence that this is how it worked. For instance, on JA 130, this is when he finished the first stage, the applicant pilot stage, and advanced to deputy. The president of the association said he's ready to be registered for the lake and to work on the lake. And the Coast Guard said, great, that's fine, because that's how it's always worked. So a lot of this is just sort of informal practice, the way things have developed over time. The regs are not always updated.
Word registered, but he became a deputy pilot. He's not registered, but he's allowed to have unsupervised access to the lake as a deputy pilot. But that's not a registration.
It is, he received a temporary registration as a deputy pilot. And what he wants is basically the same thing. He just wants it to be a permanent, or rather a 5-year registration.
But he wants a registration for both the lake and the river.
No, Your Honor.
He wants for the whole district, which is the lake and the river.
But the practice has always been that you get a registration for.
No, my understanding is he could ask for a registration for just the lake, but that's not what he asked for. He wants a full registration for the whole district, which is the lake and the river, but he did not complete the training for the river.
No, Your Honor. He wanted the registration that everyone was getting at the point that they finished the deputy pilot phase, which was, it was a full registration, but they always told the pilots, this is for the lake. It's not in the regs, unfortunately, because this is just
They had a
practice.
scheme inconsistent with the regs that said, we'll license you to go on the river when you're not yet trained to do so. That's your client's position?
No, absolutely
You
not.
just said that you'll get the full license for a river and lake, even though you're not yet trained to go on the river. That's what you just said, that that'll all come later, but you'll go ahead and get the full registration
Well,
before you're trained.
that is what the Articles of
That's
Association,
impossible.
that's what the articles say, Your Honor.
No, it's not what the training plan says.
But it is what the association's articles say, and it is the way things have
That's
worked.
your reading of it, but
That
it's
is
not what the
it's at
training
JA 143, Your Honor.
We just went over this. That's not
Yes.
what it says.
But it refers to people who are registered separately for the lake and the river. There's nothing in the regs
Can
themselves.
be registered for the lake. I understand that. But he wants to be registered for the lake and the river, the whole district, and he didn't complete his training for the river. This doesn't speak to what he wants to do.
Your Honor, he's applying for registration as it was practiced throughout the time he was there, which was that when you get your full registration, it was always a lake registration. That's how it worked for
What
everyone.
you're saying is really disturbing, because if that's true, that's extremely unsafe. And it's really hard for me to believe that the Coast Guard is running this training program this way, given what this record reveals to be how hazardous it is to navigate some of these waters. The fact that they would issue somebody, you're saying that it was common practice to issue people a registration for the river, for the lake and the river, but say, but don't really use that, just use it for the lake.
No.
I cannot believe that that's true. And if so, that's a huge problem.
No, they were not telling them that they are allowed to go on the river.
But
They
they
were
give them
issuing-
registration for the river, which means
No.
that they're allowed to go on the river.
No, Your Honor, the registration is just, it's the Coast Guard telling them, you're allowed to do this, and they tell you, you have to go on the lake, and then you do your training, and then we'll recognize that you're trained sufficiently for the river. But
So
the
you're
crew-
just repeating the same thing
So-
that I just said was very disturbing. You're saying that they're giving registrations for the lake, but telling them, don't use this, only use
Well-
it for the river, the lake, until we finally train you for the river. I cannot believe that that's what they're
I
doing.
don't think it's disturbing if you understand how this works in practice, Your Honor, which is that the pilots don't have any
What
say where they
evidence of In
go.
practice do you have?
Sorry, what?
What evidence of in practice is in the record? Then
The,
your clients say so. Tell me one other person who was given a full registration for lake and river in this record without having been trained to do the very hazardous work on the river.
I don't think anyone has, and I think that's the point, Your Honor. That they were not saying that this is a registration for both. They were saying you have a registration to work on the lake, and the association, Your Honor, tells you where to go.
So all he wants is a registration for the lake.
Absolutely. And then we can have a fight down the road
You want
about,
reservation, you said, I'm getting incredibly confused, because my understanding was when Judge Pan asked you, does he just want a registration for the lake? I said, no, he wants the full registration, lake and river.
no, he wants a registration for the lake. And that's the way it has always worked in the
Why
past.
did he apply for a registration for the lake?
Why did he apply for full
Yeah,
registration?
why did he apply for full?
Because they've always just said, they said, I finished
to apply
the
for the
training, so I've
extra one.
applied for full registration.
So you keep saying they always, but I just don't see that in this record.
What document can you point to other than his affidavit that says that you can get a full registration without undergoing any treatment, training on the river?
Well, it's not no training, it's just the complete training that would allow you to solo navigate. He has done river training. He just hasn't done as much as he would do if he were going to be a solo pilot navigating the river. But I think I keep coming back to it, but JA 143 makes very clear that you can get registration for one and not the other. And that's all he wanted. It's valuable to him because then he can work on the lake and he can make a living. He doesn't
So why didn't he apply for registration on the lake?
That's what he understood himself to be doing, Your Honor, because that's the way that this has always worked. He applies for full registration and then the Coast Guard would give it to you and they would tell them.
Then why isn't there a single letter? Maybe I missed it in my review of the appendix. Why doesn't he say, I don't have to do river training and I shouldn't have to do river training because all I want is full registration for lake? Where does he ever say that?
I think he makes quite clear, I think in his administrative appeal and in his affidavit, that the way things worked in the past and the way he wants it to be treated, is that he can get his registration and then he can do his river, his full registration, but for the lake, and that he can do his river training after. He's always maintained that he's never argued that he gets to navigate the river without having done these trips that are referenced in the association's own articles. Clearly, this is something that was practice, at least, through this time period.
So let me make sure I understand at least what you're contesting and what you're not contesting. JA 271, I asked you about that statement. Are you contesting whether there was substantial evidence in the record for the director to make the finding in that paragraph that Captain Hight has comparatively little river experience and has never solo navigated a vessel between Snell Lock to the east and Cape Kennedy?
We are not contesting that, and we said that in our brief. The argument is that that was always something that people did after they got registered and started working full-time on the lake.
In JA 107, you wrote a letter to the Coast Guard that said, based on Captain Hight's affidavit from the Hight 1 litigation, he completed 12 round trips on the designated waters, the river.
That's true.
12 round trips on the river in 2016 and 2017 when he was a deputy.
That's some of it was applicant, some of it was deputy, I believe. But
That's not what it says.
Okay.
It says in 2016 and 2017, did he do 12 round trips on the river in 2016 and 2017? 'Cause I thought you just.
2016, yes, he did.
So he's already done the trips as a deputy,
He hasn't, that's correct. He has done these trips.
as a deputy pilot.
Yes.
Were
12
they not
round trips.
supervised? They weren't
Yes.
supervised though.
No, they were supervised. The difference is that the way this has worked in the past is that these trips are done more as an observer in this stage when you're a deputy. And then after you get registration, then he would take command and actually have his hands on the controls and be the one doing this all with someone else just
That's not what
watching.
you're saying. You said in this letter that he completed the training, which he didn't just sort of which isn't standing there and observing, it's doing the piloting. And you said here he did it 12 times, and then you're agreeing over here he hadn't done it. He hasn't done it more than
Yeah.
once. And so I'm getting confused as to what's going on here.
So
I mean, I had thought we all agreed at the beginning, he had not completed the statement that Judge Wilkins read from the Coast Guard Emerson decision was that he hadn't completed the trips. But you had previously written that he had done 12 trips as a deputy on the river.
That's correct.
As a pilot. Was he were these qualifying training trips? It seems like you wouldn't.
These are,
give us all this
these are the
stuff.
training, sir, Your Honor, these are the trips that are referenced in the training plan. These are the trips that deputy pilots have always done. The difference is that the practice has always been, and this is detailed from 253 to 59, that after you get the registration, then you do different river trips where it's really you on your own, and it's more like, you know, your driving test where someone there is there actually watching you. These
What
were
did he do on these 12 trips you were referencing the letter? He just observed?
primarily, he's on the bridge, he's talking to the people, he's learning about the waters, but he's not the one, you know, with his hands on the
Then why did you
controls.
tell the Coast Guard that he'd already met the training requirement?
Well, we did. We have since
Is
Hight
that the
1.
training requirement?
That's not what's referenced in the association's articles, and it's not, I don't think that's,
So here's how I understand your argument. Tell me if I'm wrong. You concede that for purposes of the training, he made only one trip that was supervised on the river. That's in the record. It seems to be uncontested. And so based on the Coast Guard approved training plan, he didn't comply with the Coast Guard approved training plan because it says you have to make trips plural in the designated waters, which is the river. So he didn't comply with that. But your argument is, even though he didn't comply with the letter of the training plan, there was this whole unofficial practice. And he has not been treated in accordance with the way other people were treated under this unofficial practice.
no,
that your argument?
no, I'm sorry, Your Honor, that our contention is that these trips he took are exactly what's referenced in the plan, but that what the Coast Guard is referring to now is an unwritten additional requirement, and that's what is referenced.
What's the unwritten additional?
That's what's referenced in the association's articles when they talk about this river training plan that goes down in order of seniority. And in the past, and again, this is detailed in the declaration.
I'm sorry. I'm trying to understand your argument. Okay.
No,
So you're saying that it's true that he only did one supervised trip in designated waters and didn't comply with the Coast Guard approved training plan that's in the record at JA
no,
135. But there's this river training program. There's this completely different training thing, which made it hard for him to do that because he was not an associate member who was temporarily registered for the lake, which would have had priority.
no, sorry, Your Honor. We are not conceding that he failed to do anything that was in the plan. We think that those 12 trips are the continuing river trips referenced in the plan. What we're talking about is the unwritten requirement that he do solo navigation trips with someone watching him. That's not something that happened prior to full registration until after this case. It was not the way things worked while he was there, and that's what's referenced in the association's articles.
So it says, the approved training plan says he has to continue to make trips plural in designated waters of the pilots in the company of registered pilots. They're saying he only made one. You're saying, no, he made 12. So why isn't that? I mean, my understanding was that was not a contested fact, that he had only made one. Where is it that he says, I made 12 and you're wrong about me only making one? Where's that in the record? I don't remember seeing that.
Well, I don't have the J for that. It's certainly in our brief. But
Where in your brief?
don't have that to hand. I'm sorry. I think the key point though is that it wasn't,
Provide a side on rebuttal.
sure, is that there wasn't a dispute about whether he took the trips that he said that they took. The dispute was whether he had done enough solo navigation of the river to be able to take command by himself without any observation.
Right, so they read the trips on the designated waters to be solo navigation with a supervisor. And you read designated trips on the water to be just being on the water with other people. Observer.
Right, because that's right. And what he's always said is that this is how it has always worked, that you go mostly as an observer while you're a deputy pilot, and then afterwards, then you do the solo navigation.
But it's a
After they
pilotage
license.
program. It's a pilotage program. So make trips in the designated waters. You have to be a pilot when you're making trips in the designated waters. You can't just sit on the boat. That doesn't count as making a trip. You can't just like go on like a pleasure cruise on the St. Lawrence River, and that wouldn't be making a trip. He has
Of course not, of course not. Well, no, these are still educational trips. Your Honor, well, for one, he is a pilot. He's got his temporary registration for the lake. He's got his license, and he's going there learning about it.
But
He's interacting.
But
He's
if it says
observing.
make trips in the company of a registered pilot, why doesn't that mean you're piloting and somebody is supervising you? A registered pilot is supervising you.
Because that's not the way it had ever been interpreted before. Because the constant practice, and he has always maintained this from 2018 to today, is that these were primarily as observers. And that's not worthless. If you're up there on the bridge, you're talking to people, you're getting to see this is the river they're going to be navigating, you're learning a lot. You just aren't yet the one with the hands on the controls issuing the orders.
So that's like saying that, you know, like one of my kids should be able to get a license to drive a car after they've, you know, made a minimum number of trips, you know, sitting in the front seat, watching me drive. But they've never solo navigated under my or anyone else's supervision the car. But they should be given a driver's license to go drive because they have taken the requisite number of trips watching me push the brake and the gas pedal and turn the steering wheel, et cetera.
So I think
That's the way
No.
of saying that this works.
No, the problem with that analogy, Your Honor, is that my client is already a licensed pilot. He's registered for the lake, and he's been a captain of huge ships on the high seas for many, many years. There's no dispute here that he has the skills to do this. What he's learning is just these specific waters. And he's learning a lot by being there on the ship, seeing the waters, interacting with the people who do this regularly. It's not a worthless experience. And he's not even arguing that alone.
No one says it's worthless.
Right.
The question is whether it's qualifying.
Well, it qualifies under the plan, at least.
Can we just clarify? So the district court made a finding, it's a JA 293, that he made 2 one-way trips on the St. Lawrence River in the 22 months after May 2016, which was when he was a deputy pilot. And only one of those trips was supervised. Therefore, only one of them would count for purposes of the training plan. The other trips apparently were from before he became a deputy pilot.
I believe
If that's not true, I would, maybe on rebuttal, you could tell us where in the record.
I think they
shows
were
that
in
those
early
trips were-
2016. So before he got
before
some
he
of those
became a
were
deputy
were
pilot.
before he became a deputy.
Okay, so maybe you can tell us on rebuttal, like where it says that
It's all the-
anything
I
other
think-
than these 2 were when he was a deputy pilot.
Really, a key problem though is that he doesn't have any say over where he goes. That's not how this works. You go where
I'd
you're
like to
dispatched.
understand too, because it says here that he chose to be on the lake because he was making money. And he didn't choose to do his training on the river.
Right,
which I
that's-
guess you're gonna
that's-
make money for the training.
Well, that's what the association said, and it's not the way it's ever worked. And it's still not, if you look at the letter that the association sent to the Coast Guard, JA 130, it says he will be dispatched because they have a dispatch organization, an office. They run the tour de rôle, so they tell people where to
No,
go.
I understand that. I
Yeah.
mean, he wants to be on the roll and he wants to be dispatched on the lake because he makes money. But then he has to take the initiative to complete his training on the river, because I assume he's not getting paid for the training trips. But he has to make that happen for the training. They don't dispatch you for training unless you
They-
ask for it.
No, they do dispatch you for training. He always went when he was told, and everyone else did as well.
So you're saying the way it works is when you're a deputy pilot and you need to fulfill this training obligation to make multiple trips on the river, you just wait until somebody dispatches you to go on the river for your training?
That's right, because you can't take yourself off of assignments. You go where dispatch tells you, and someone else has to say, okay, I'm on the training committee. I've got some time. I'll take him on this one. But
You don't have to sign up for a,
no, this
you
is,
do nothing but wait.
the training committee is supposed to tell them, and this is what the plan says, that they're going to tell you what you're supposed to do. But there's nothing, I think that this is all downstream of the really fundamental issue, which is that
So where in
If-
the record did your client argue that he was waiting for somebody to tell him and dispatch him to do his river training?
I am not sure if that's in the record, Your Honor, but I think that this is a little bit beside the point, because we would know how all of this works if the Coast Guard had taken an hour to look at the records.
Well, hang on a second. So,
That's a different.
yeah, we're getting a lot of different arguments here and we're trying to understand them. So if, as I understand it, and tell me if I misunderstand it, Coast Guard has its description of how this process works and what's required. Your client has a different understanding of what that process is, what's required and how it works. Right? There seems to be a real clash.
No, I think that the clash is between my client's understanding and what the association has represented to the Coast Guard. I don't think the Coast Guard.
Coast Guard has its requirements and its understanding of what's going on. But I'll even take your version of it, okay?
Okay.
The association has its version and your client has its version. And the Coast Guard has credited the association version. And we have some written documentation evidence from them. You may disagree with, you may read things differently, but we have evidence on that. But we don't have evidence beyond your client's say-so, which would not be sufficient for summary judgment, as to, well, what really happens in the real world. You get these full licenses, even though you're not fully licensed and you still have to do the training. Given our standard of review, how can we say the unsubstantiated understanding, we can assume it's genuine, but it's just not evidenced, can override the Coast Guard's crediting of the association's description with documentation?
So before we even get to the standard of review, I think the threshold is you have to rationally address these allegations. At no point.
We start with standard of review, and that's how we even analyze whether there's a rational address of something. And part of that standard of review is there any evidence in the record?
I'm sorry, I misspoke. I mean, the standard of review, there are two issues here. One is arbitrary and capricious, and the other is substantial evidence. I don't think we get to substantial evidence until we have an actual explanation that we can make sense of.
I would like an answer to my question, which really was a substantial evidence question, about they said, he said. And because there is a declaration from your client, assume that's his correct understanding. And so the agency was presented with two alternatives, and it credited one over the other. And one had documentary evidence, and one had a declaration. And what in our standard of review would allow us to say the Coast Guard should have credited the unsubstantiated declaration?
So I agree.
That's critical to your, at least your.
So to be clear here, we're not saying the Coast Guard is required to credit what my client said, though I do think that the JA 143 is documentary evidence supporting my client. But what we're saying is that the Coast Guard has to have a rational explanation for why it's crediting one account over the other. And I think that is particularly true in a case like this, where the Coast Guard has the answer. It has this information, and it is super easy to find out. It can't be rational APA decision-making to say, look, we have a dispute of fact, and instead of just opening the files.
Let's be crystal clear. We have a disputed allegation and the documentary evidence from the association. There is no, because we're struggling with your J143 point. So let's say that's not a slam dunk for you. Okay.
Sure,
so,
but it's something.
Well, that's debatable on how you read it. So I don't want to, we cannot equate this as a summary judgment dispute of evidentiary substantiated facts, because we just have a declaration of this is how I believe it always works, which would be perfectly fine for a complaint, but not for summary judgment. And so I'm struggling with how we're supposed to, because your argument keeps coming back to, frequently your response is, well, here's how it's always worked. Here's how it's always worked. And all we have is one person say so. And I don't know why the Coast Guard would be compelled to accept that.
I think it's essential here. If this were something that is unknowable, that the Coast Guard couldn't possibly figure out.
So an allegation without substantiation obligates, you want us to write an opinion that says that allegation without substantiation, but we assume in good faith, obligates the agency to go find more evidence and gather witnesses and documents.
Not necessarily a huge open-ended investigation. All he said.
I didn't say how Jordan, you're saying,
Sure.
tell me what's wrong about what I'm saying. You said the obligation, you've said many times, it wouldn't take long, it's easy. So that's an obligation on them to go gather evidence. That's the opinion we would have to write for you to win, your client to win.
At least, I think it's a flexible standard. If the requirement, if figuring out the truth would be a huge burden on the agency, then it might be reasonable to say we can't possibly figure that out. But from the very beginning, he said, this is really easy. You just have to look at the files. And the Coast Guard never said, I think this is
Like a
important.
legal case or something that supports your, if it's easy to do, they should do it, and if it's not,
Even
we
if
don't
it's just
have
an
to.
allegation.
Like,
I mean, I think this is implicit in our, I don't think that you can have reasoned decision-making that says we have a factual dispute and I could just look at this to figure out who's true, who's telling the truth, but I won't. But I think that NTE Connecticut is the case that says that you have to at least articulate a reason that you're crediting one over the other. We're not even saying that they had to, we are absolutely not saying they had to credit what my client was saying. We're saying that if they're going to discredit it and credit someone else's, they had to
can't they discredit
articulate
it
a
and say you
reason.
haven't offered any evidence?
Well, they didn't do that, Your Honor. And that would be a different case because then we would have done more. If they had said, look, or if back in 2018, I
If
mean,
they
we were,
said you haven't offered any evidence, you don't get around to.
if in
You don't get around to.
2018,
No,
it-
we're talking, we review the final agency decision. I'm not reviewing the prior stages.
and the
Final
fi-
agency decision, you don't have evidence.
and the final agency decision doesn't say there's insufficient evidence of this past practice. It doesn't say, I find what you're saying not credible. It just says, this is what the agency said. It basically ignored everything that Captain Hight has been saying since 2018. No one has ever given a response and said, well, we don't have enough evidence that this is how it worked. If you can show us, maybe it's different. They've never said, you're obviously wrong. They've never said, we looked at the records and we don't think that's how it worked. There's none of that's there.
Let me see if I can skin the cat a different way. The regulation at issue here, section 402.220, the registration of pilots regulation. You're not attacking that regulation as invalid or anything like
No.
that, right? Isn't it a reasonable reading of that regulation when it says that an apprentice pilot must complete a minimum number of round trips, and where it says a minimum of 5 round trips are required over the waters for which registration is desired? Wouldn't it be, isn't it a reasonable interpretation of that regulation to say that there should be at least 1 round trip over the river, since that's part of the waters that you are requesting registration over?
Your Honor, the answer to that's really easy. Hight 1 decided that. It decided that under the regulations, Captain Hight has satisfied that minimum trips requirement. That's why no one's talking about the minimum trips requirement.
Hight 1 didn't decide that issue with respect, sir. Hight 1 decided an issue as like whether he can take a test. It didn't decide whether he could ultimately and should ultimately be registered.
That's true, but the reason he could take the test, what the agency was arguing was that he hasn't done the minimum trips under the regs. And Judge Mehta rejected that as contrary.
Rejected their date from which you counted trips. They had a different date. Regulation says from date of application. They had a different interpretation of what application meant as opposed to his application. That's a completely different question.
And are we bound by what the district court says?
Well, I think it's res judicata as to these parties, at least. They didn't appeal that.
Hold on. Judge Mehta talked about minimum requirements. And now we're talking about requirements for registration, which is more than the minimum. So we're talking about 2 different trip requirements in Hight 1 versus now, correct?
Well, yes, they are not talking about the minimum trip requirements in the regs at this stage.
Right.
They are talking about something that they still cannot pinpoint.
Correct, but just Hight 1 doesn't resolve what's before us today because we're talking about the number of trips you need to be registered, not the minimum number of trips that you need.
Let me, we're not playing poker here. I'm just going to tell you how I interpret the decision on appeal by Director Emerson with respect to training. What I got from all of this, after trying to go through all the briefing and everything else, is that ultimately what Director Emerson says is like, look, it appears that you haven't that Captain Hight did not solo navigate this part of the river under supervision, and at a minimum, he needs to do that at least once to be fully registered, and he hasn't done that. And you're not contesting that finding. And whether or not others got full registration without having done it or not, he doesn't address that. But, you know, under the rule of prejudicial error, I guess what I'm trying to figure out is that even if the director said, you may be right that 10 other pilots have gotten full registration without having done a solo navigation trip on the river, I read this regulation as requiring that to be the case, and you haven't done it. And you're not qualified, and I'm not going to give it to you. And, you know, maybe we'll have to deal with these other people, but I don't know of a case that says that if a government official reasonably interprets regulation to require something and you haven't met the minimum requirements, that it is arbitrary and capricious decision-making for them to not let you get your license when you haven't met the minimum requirement that it is reasonable for them to have required you to meet.
So I understand, Your Honor. So two points. First, he didn't ground it in the regulation itself. He didn't say that this isn't meeting the minimum trips requirement. So we don't need to consider that. But the key issue here is that
We don't think that he considered the regulation that governs the decision.
it's not, well, I think there is a good reason for him not to base it on that because of what happened in Hight 1. There's a reason that the government isn't talking about the regulatory minimum trips requirement. We already litigated that, and they didn't appeal it. Now, I think that if he had written an opinion where he said, wow, it looks like none of these guys should have been registered, well, you're not going to get registered, but we might have to look into that. That would at least be an effort to comply with Baltimore Gas, where you're addressing the inconsistent treatment. But he didn't do that. We're not suggesting that he's bound by agency precedent to never change policy. What he has to do is engage with what past practice has been and offer some kind of a reasoned explanation. And he just didn't do that.
It seems to me that once you concede that reading of the regulation is reasonable, your argument fails.
Your Honor, we don't. We just think it's decided by Hight 1. I think the reg is pretty clear that it says that trips have to be made in the company with a registered pilot after application has been sought. And those requirements are clearly satisfied. I think that's what Judge Mehta said. And they didn't appeal that. So regardless of whether this court thinks that's the right interpretation, I think the agency at least is bound in this proceeding.
Just seems to me that at bottom, you're relying on unwritten, informal understandings that are not clearly laid out in the record anywhere. Even aside from the fact that they're unwritten, unofficial, they're nowhere laid out. Like, I don't see, and tell me if I'm wrong, your client actually saying, this is actually the way it's always been done. There are some vague references to I'm being treated differently, but there's never a specific sort of outlining of what he thinks the process is supposed to be.
So-
If it's there, tell me.
Yeah, I mean, I think
don't see that.
if you want the most detail, it's from JA 253 to 59. That's where he goes through how this has always worked in the past. And I agree, this is unwritten practice, but the problem is that's all the other side has too. I mean, at most they can say, continue to take trips, but they know that what the trips are supposed to look like is not specified, how many is not specified, and they haven't grappled yet with the river training in their own articles. Whether you think that's conclusive or not, it doesn't fit with the way they are arguing things have always been. And they don't have any explanation for that.
So, paragraph 96, I just went to the page that you told me to go to, but it seems to contradict what you said about they're just waiting to be dispatched to river training. It says, after pilots advance from applicant pilot phase to deputy pilot phase and receive temporary registrations, we rarely had time to take trips on the river, working primarily on the lake, particularly when rest requirements were enforced on training trips. Prior to 2016, this was not enforced. That doesn't say that they don't dispatch us. He's saying that he doesn't have time. It seems like it's incumbent on the deputy pilots to plan their river training despite their commitments on the lake. And that's consistent with the findings in the record by his superiors that say he prioritized the lake training because it was paid. I think it was incumbent on him, it seems, to sign up for the river training.
I can understand it. I don't think that that's clearly stated one way or the other. The way he's explained this to us, Your Honor.
So where in here does it say we are waiting for people to dispatch us?
I don't think it does, Your Honor.
So
But
that's not in the record anywhere.
I'm
So we
not
can't
aware of
consider
that. I'm not aware of that being in the record, Your Honor.
Okay, so we can't consider that.
Any other questions? Took
Thank
it
you.
up for a long time. Thank you, Counsel. We'll give you some rebuttal time. All right, the Justice Department now, Mr. Dos Santos.
May it please the court, Josh Santos on behalf of the United States. I'll just start with what is at issue here was just a request for full registration to be able to pilot by himself in the waters of the St. Lawrence River, which are particularly hazardous for the reasons that the Coast Guard explained in its decision. And what the Coast Guard said was you haven't met the requirement in 420.220B2 that you complete a training program by the Pilots Association that are local experts in those waters. During the second stage of your training program, the deputy pilot stage, he only had a single half round trip that was evaluated, and that wasn't enough to show that he'd continue to make trips, plural, demonstrating his proficiency. And the Coast Guard just wasn't going to authorize someone to pilot by themselves in this particularly dangerous area when they haven't demonstrated their proficiency. On the other arguments we sent in our brief, I welcome the court's questions.
What's your understanding of how that works? Your friend on the other side says that in order to make the trips on the river, they're waiting to be dispatched there. Is that the way it works?
My understanding is the dispatch has to do with the lake portion, because when they're in this deputy pilot stage, they have the temporary registration to work on the lake and they go out on their own. So they're dispatched normally. They get their pilot's earnings the same way that other pilots do on the lake. So that's what the dispatch is about. But they would have to request to be put on training trips on the river. And that's
So
what the
there's
Coast
no
Guard,
dispatch on the river for people who are not full members,
that's my understanding.
or at least temporary members.
Right. My understanding is you seek out training opportunities, and that's what the Coast Guard was referring to in the decision, saying you focus on the lake and you didn't make time to complete trips on the river.
What do the regulations say about how many solo navigation trips on the river are required to get the full designation?
So there's the minimum trips requirement. What's at issue here is the training program, which is also you're required to complete it under 420.220B2. The training plan has the two stages. So in the first stage, there's a certain number of required trips. The second stage at issue here says you will continue to make trips to demonstrate the proficiency. And that's the part that the Coast Guard said was lacking here, because there was only one single half round trip that was evaluated.
Just so that I'm clear, what regulation are you citing here?
So the regulation that I'm talking about is, it's 46 CFR. I think it's 401, excuse me, .220B2. And then the training plan is the one we've been talking about from pages 130 to 37 of the appendix. So you can see on page 135, that's the requirement that's at issue here. The applicant will continue to make trips in the designated waters, plural. And let me just emphasize this program, it's basically like an apprenticeship program with the experts in these local waters. So, I mean, some people learn faster than other people, and the trainee will be given more and more control gradually until the program sees that they can handle
There is
it.
no set number of trips that you have to make, but it's more than one, because it says trips, plural.
It's more than one, and
So
it's
This
just
would be a harder case if he had made 3 trips.
potentially,
Or 2
right,
trips.
it would still be squarely within the kind of the expertise of judgment about safety and
No, I
whether he's
understand that,
adequately
but it would be a
prepared.
harder trip because he's made less than 1 and this says trips.
That's right.
What are we to do with his declaration, which says at great length, the trips I did before I became a deputy on the St. Lawrence River should count?
So that was during, I think, undisputedly during phase 1 of his
I
training.
understand, but why shouldn't that count? He says that's what's always counted before. Why shouldn't those count? Do you do something different once you're declared a deputy pilot? Do you have any different role piloting than they would have had as an applicant in those trips he did as an applicant pilot?
So my understanding is that during the applicant pilot phase, they're mainly observing, and then in the deputy pilot, they gradually get more responsibility with the goal of them being able to solo pilot. You can see on 137 of the appendix, I think those are the standards of evaluation, and you'll see that it references.
Are you talking about their training plan?
Yeah, at the end of the training plan, there's the standard for like the grades that you can get, and those reference like ability to solo
I'm
pilot.
sorry, what page are you on?
137, I believe, unless I've miswritten it down. But those standards, like those are basically the way that they would be evaluated, right? They could get a 0 if they didn't know what they were doing, a 1 if they're just adequate, and a 2 if they demonstrate really great and exceptional knowledge of all of the hazards. And there you can see that
So I
it's
think that the only one that talks about soloing is excellent performance, which isn't required to get your license. The
Right, but
other 2 simply talk about acceptable proficiency, little coaching, understanding of critical areas doesn't mean that you've piloted through them.
Well, acceptable says you have to provide pilotage services unaccompanied. You have to display the skills to provide pilotage services.
right. The goal here is to get the person ready to be
Mhm.
on their own by themselves in this river. And like, as the Coast Guard explained, I mean, this river in particular is dangerous because of
Displays
all
the
of them.
skills and knowledge to do something isn't the same thing as doing. I mean, I'm just contrasting 1 and 2, which actually says they've soloed under supervision between 2 being excellent, 1 acceptable. Do we know that it displays the skill and knowledge to provide pilotage? I mean, people supposedly on the bar exam display the skills and knowledge to be a lawyer even without actually practicing law.
Yeah, so
Pass the bar exam. And that's different from saying they've soloed handled a case.
right. What I'm saying here and what the Coast Guard said is the single half round trip did not show that you have the adequate knowledge and experience and ability to
Why
do this.
would they just look at that one and not also look at what they did as an applicant?
This is.
Couldn't that show skills and knowledge too?
So there was a decision made to promote him, right? So he was an applicant, and then there was a decision made, you've done good so far, we'll promote you to deputy pilot. The Coast Guard approved that. Then he was a deputy pilot. Now he's in the second stage. And then he has to show that he's going to learn enough to be able to go by himself.
I'm trying to understand is that, so you say during the applicant stage, when they're on the river, because that's what matters here, they're not really piloting, they're just observing. Do they do any piloting during the applicant stage?
I don't know that it says they can't. I think primarily they're observing. And I think that's what has been admitted that he was doing here.
Coast Guard thinks that based on what?
That's my understanding of, based on conversations.
And then,
And also just, it's admitted here that he was only observing in the applicant pilot stage of his training.
right, so all this stuff, this makes perfect sense, but it doesn't seem to be written down here.
Yeah, well, what the part that's written down is that he has to continue to make trips to show his proficiency. And he had only half a round trip, only one half round trip that was evaluated. And that was not enough. And that's perfectly
He
reasonable.
says that's not, what about his argument that that's not how it's done, that people get their full registration? You count all the trips they've done since they first applied, the applicant and deputy. That's how it's always done. And then, of course, I'll get more training after that, but you count everything cumulatively.
Well-
His central argument is, here's how it's always been done. And he names people in his declaration. And where is the answer in the record to the, no, that's not how it's been done? I can't tell from reading the decision whether this is a new interpretation or the one that they've always applied.
So I think that this is the training plan that was approved by the Coast Guard. And there's obviously 2 stages to it. So that means that there are 2 different parts of the training. The person is promoted from one to the other. So in the second part, continue to make trips means more trips, not the same trips. You continue to make trips, more trips. And then, so like the bottom line here is just that you didn't do that during your second stage. And I'll also just note, it's very implausible to think that someone would get full registration, which means authorization to be piloting by yourself in the particularly dangerous areas that we're talking about here, without having had more experience and done more trips during the second stage, which is supposed to be leading up to being able to do things on your own.
So what about Baltimore Gas? Your friend on the other side says, look, it's not reasoned decision-making where he points out that he's done as much training as other people who have gotten the full designation, and he gets no response to that other than, we're not discussing other people here.
Right, so I
He
think,
says Baltimore Gas requires an investigation and a response.
so I'm not familiar with the particulars of that case, but I think what he's referring to is just past case law saying where the agency is departing from its own prior decisions. I mean, that is not what he alleged. And as was pointed out earlier, all of the references to other people, first of all, they happened before Hight 1, and it was about whether they can take the test issue, right? And then later, I think there was only one reference to Wiegler, which was pointed out earlier. And even there, that person was required to take more trips before registration. So there's really nothing spelled out, no person with a particular number of trips that was comparable to him. No one that he says also had a single half round trip on the river and then got authorization to go on their own.
So you're saying that when he mentions the, 10 other pilots or however many it was, that he says were treated differently, he was only saying that with respect to they were allowed to take the test. Whereas
Yes.
you're not allowing me to take the test.
I think almost all of the citations that they have are to parts where they were making that argument about the test. I think there may be one about Wiegler that came later. And in that one it's the person that he admits was required to take more trips. But the idea that someone could get full authorization to pilot on their own and then do their training later, it's just not supported, and it would not make sense.
Well, how many trips are required in order for a person to be qualified to obtain their full designation, their full registration?
So under the completion of the training, which is what we're talking about here, there was no specific number, right? It's kind of a qualitative thing. If someone had been on this river, like as a master, not a pilot, for like 20 years, and then they do this, maybe they need fewer trips. If someone is brand new to the area and they may make some mistakes, maybe they need more trips, right? But it's a qualitative evaluation, like an apprenticeship program, where they gradually give over the controls till they see, okay, you understand how to do this on your own, and we're confident that you can do it.
But where is the answer to his declaration on JA 254, paragraph 98? He says, only after a pilot was fully registered was he allowed to pilot a ship on the river under an experienced pilot supervision. That's a very requirement that here was imposed on him to get full registration. And he said, this is not about taking the exam. This is about getting full registration before you're allowed to start piloting up the St. Lawrence River, given how hazardous and dangerous it is. This is his experience. Where is the answer to that?
So the answer is the Coast Guard approved training plan does not say that. It says that you have to continue making trips as a deputy pilot.
You've got a conflict.
Right.
Where's the resolution of the conflict?
Well, the Coast Guard applied its approved training plan, right? So, I mean, the idea that you could get, and I think the decision actually says, I'm not going to risk safety by approving you before you complete training, right? Like, even like you're saying all these things about you being able to do that. I'm not going to risk that. The Coast Guard approved training plan says you've got to keep making the trips to show your proficiency.
Yeah, but the argument in this case is he did the same thing everybody you authorized 5 previous times had done.
Well,
So why are you making up the sudden new rule for me? That's seems to be the main thrust of the argument, at least today. And where is the answer to that? If there's a conflict, he's asserting this, and the association plan says one thing, and its articles of incorporation at least or its articles are at least confusing at best. So why didn't the Coast Guard need to address that conflict in the evidence? Could have done it easily, but why didn't they need to address that conflict in the evidence instead of just going, well, here's what we're doing to you?
Well, so I guess I'll just say what was pointed out earlier and what we've explained in our brief, which is just one person's say-so is not enough to trigger kind of this broader inquiry into sort of looking at all records for past people. I mean, the Coast Guard had was its own approved, right, training plan for that association, and it applied its terms. And I think it also just makes good sense. I don't think it makes sense to think that the Coast Guard was approving people.
It'd be easy for the Coast Guard to say, no, you're wrong. We've never registered someone who doesn't have at least more than one trip on the St. Lawrence River.
Well, so what you're looking at, obviously, under the APA is a reasonably discernible path to the conclusion, which I think is just obvious here. And the Coast Guard explained in detail its concerns about safety.
Explain in detail concerns about safety generally. But if you're that concerned about safety, trips plural with no further specification does not give me much comfort.
Well, again,
All right, so you did 2. We've told you how hazardous and dangerous this is, but that's sufficient. There's not an explanation of this contextual inquiry. It depends on your background and experience. That's not in this training plan that's approved. This plan,
I think you should
happen to use the plural trips, and that seems to be everything that it's hinged on here. And he says that's not what you've done. He says in terms, that is not what you've done in the past.
So I think it's nice. It's a good idea to take a step back, right? We're not talking about a simple checklist. This is a particularly dangerous thing. Lives are at stake, and commerce, you can cause lots of havoc if a ship gets stuck here. We're talking about you can't come rescue them. Okay, so like the way that this works across the state since before the founding is you do an apprenticeship with people who are experts in these local waters and these local dangers, right? So it says continue to make trips to show proficiency. Yes, there's no like you do 2 trips and you're done, right? It's that you're being evaluated by people who know these waters and can see if you're ready, right? That's how the apprenticeship program is set up and how it works. And here you have a single half round trip, and that just wasn't enough.
Let's suppose he had brought to the attention of the Coast Guard during the administrative process. He had, 2 people who submitted affidavits, under oath, that they had received their full designation without having done any solo navigation at all, as part of the training program. Would it have been appropriate for the Coast Guard to say, look, we don't care, we don't discuss other mariners. You haven't done, you've only done kind of half of a trip. And we don't feel that that qualifies you. And so we're denying your full registration. Would that be, would that have been an appropriate decision?
I think in that hypothetical, yes. I think the agency can certainly say, well, regardless of what happened in those cases, we just don't think that you're ready for this. We don't think you've completed your training program, and we're not gonna depart from the face of the program that we approved and give you authorization to solo.
And they wouldn't have to explain why those people received full registration and he didn't. They would bear no requirement to explain the differential treatment.
I think if there had been some kind of appeal in the other ones and then something had been decided at a higher level of the agency, then there might be a requirement to deal with it more specifically. But I think when there's just an assertion that it's been done differently in the past, I think the Coast Guard is certainly within its discretion to say, well, regardless of what happened there, we're not going to do it here.
So I'm not sure I understand.
I mean,
I'm not sure I understand your last response. So it's not just an assertion, they have evidence, and let's just for the sake of the hypothetical, let's say they attach training records and everything to pretty much prove it indisputably that they didn't do any solo navigation trips during training, but they got the full designation. At least 2 others did. My question to you is it a violation of the APA for the director under that circumstance to just say, look, I don't care about other mariners. I believe that the requirement, the registration and the training requires at least 1 round trip solo navigation under supervision, and you haven't gotten that. And I'm not going to discuss the other mariners and why they did or didn't get, or why they did get it, I guess. You think that would pass APA review if that were the record before us?
So on that hypothetical, right, and you're saying the agency addresses it and says, regardless of what happened in your case,
we're not going to discuss these other people.
Yeah, I mean, I think so. It's not this case, but I think so. I think.
You think that would survive review?
Yes, because I think the agency would be addressing it and it would be saying, regardless of that, we're still sticking.
You might have substantial evidence. How is that not the definition of arbitrary and capriciousness? It's today we're enforcing the rule. Last 2 days we did not.
Well, I think obviously changes in position happen all of the time. And so long as the agency.
You were posited a completely unexplained one that just said, we're not going to talk about that. Where has ever said that we're not going to talk about them is a sufficient acknowledgement of a change in position? Where have we ever said that?
So I'm dealing with a hypothetical without any particular facts,
Well, you're making an argument
like an actual
about what the APA law is.
Right. But based on facts offered to me.
APA law that says it's sufficient. You said agents, and your response was agencies can change their position.
Right.
But the posited hypothetical was where they said, we're just not going to talk about that. My understanding of the law is if the agency is going to change position, it has to acknowledge the change in position, acknowledge any reliance interests, and give a reasoned explanation. It's not a heavy lift, but they have to do that. But you're now, I understood your answer to Judge Wilkins to be that it's perfectly fine for an agency to go, we're just not going to talk about that.
So apologies if I misunderstood the hypothetical. If the agency says, I don't want to talk about it, sure, that wouldn't be enough,
We're not
right?
going to,
If the agency says,
we're not going to talk about those other pilots.
so this was in the prior stage before Hight 1, and what he said is, I'm not going to discuss
Not the hypothetical
with
you
you.
were just given.
So
Do you want to answer his hypothetical again? If you're given, here's what I have, my half trip or my 1 trip, but I don't have trips plural. Here's my evidence that Monday and Tuesday, you gave full registration to pilots who have that same amount of training that I have. And the agency response is, I'm looking at the plan, it says trips plural, I'm enforcing that as to you, I'm not going to talk about what happened with those other two. I think that was the hypothetical. What is your answer?
So I think there, if they say, I'm not going to address it, that wouldn't be enough. If they say, on the other hand, which is what I assumed was the question, if they say, whatever, you say that it was inconsistent, even if it was, we don't think that that should be the standard to govern, and we are applying the training plan that we approved as written, I think that would be addressing it and explaining the reasons why you're still applying the terms of the training plan. That's what I was trying to say.
I'm not sure that would be acknowledging a change in position. That would be saying, oh, we're not going to figure out if we've changed position. That was your answer now is, well, we're just not going to tell you whether it was a change in position, even if it was whatever. This is what we're doing now. I don't think that's enough.
I think it's enough to explain why you're doing it despite potential inconsistency in the past. But again, this is not the case here, right?
Well, you have an assertion here that this is not how the system works. And in fact, you also have the additional assertion that, how am I supposed to get these trips? I don't have control over whether I get to pilot something on the St. Lawrence River.
So I don't think that there's, I'm not aware of a place in the record where he said that he wasn't being trained and they were stonewalling his request for training. I think the only thing that he did was to say, I'm qualified, grant me full registration. And the Coast Guard said, we don't think you are, and we're not going to give you authorization to solo pilot.
What does it take for a court to be concerned about it? What has to be in the record for us to be concerned about inconsistent treatment? Why is his declaration not sufficient?
Well,
Evidence.
yeah, I think an assertion of just, you should look at other records because I think you're treating me.
I'm talking about a different assertion. Paragraph 98, JA 254. Only after a pilot was fully registered was he allowed to pilot a ship on the river under an experienced pilot's supervision. That's the trips that they say he hasn't done. Pilot a ship on the river under experienced pilot supervision. He says that can only happen after they're fully registered, not before. So he's in an impossible catch-22 if you say you got to do it before you can get registered, but he can't do it. They won't let him do it until he is fully registered. Where is that? So that's his declaration. That was before the agency. Where is it addressed?
He took a half round trip, so obviously he could do it. And then other people were.
He only took a half, and one could interpret that the other way. The best he was able to get was a half round trip. So
I think you have that. I think you have the fact that even.
Yeah, that's not the agency's explanation. That's not an agency's response. They don't even acknowledge this assertion.
I mean, I think if someone is just saying everything works totally differently than what's actually written down, right? And you just apply what's written down, I think.
He made a specific assertion about how this plan works in practice. Why didn't the Coast Guard need to respond to that before saying you have to do something that you have told me the association won't let you do? Why is that a sufficient response?
I think it's sufficient to apply the terms of the actual plan.
Someone says you can't do it as written. They may say that, but you cannot do it as written.
But
Here's how it works.
I think recall that the plan has to be approved by the Coast Guard. The association can't just do what it wants, right? So like saying you need to first figure out like what the association does. It's not really the question. The question is the Coast Guard approved plan.
What was he supposed to do? He said, I can't get these. It's not how the association does it.
He
How is he
certainly,
supposed to get the training?
so he certainly could have said, they're not letting me train. Please intervene. And the Coast Guard certainly
That's
had
what he said,
authority.
is I can't do these trips until you give me the registration.
What he said was give me full registration.
What he said is I can't do these trips until I have full registration. That's
Yeah,
different.
the Coast Guard is not going to grant full registration until you finish. If he'd said, I want to do the trips, make the training, make the association do it because they're
Right,
saying
but
that I
he
can't.
Made assertions about what the association was doing. The Coast Guard response was that's between you and the association.
That was, he said, they're not putting me on the tour de role for the lake stuff for which he was temporarily registered, right? And there it's like, he's working like other pilots on the lake. And the Coast Guard said, we're not going to intervene in the way that dispatch is run because that's what the association's for. They dispatch people for, like the pilots who
They
are
also
working.
do the dispatching for the river. You've already told
For
them.
people who are, there's two different things, right? There's the training program on the river, and then there's people who are registered to work on the river. they are dispatched to the river. People who are seeking training would seek it out.
Any other questions? Great. Thank you very much, Council.
Thank you.
Mr. Longstreth, did I say that right?
Yes, for the association. Again, people have been up here a long time. I don't want to labor it. Starting with where we were before, on the trips. And I think this is where we started in the argument. It is written, and this has been pointed out before, and there was a very strong allegation in the reply that this requirement that he undertake the trips as a deputy pilot wasn't written down anywhere. And as I think you started, Judge Millett, it is written down right on 135 to continue to make the trips. There was some confusion when my friend was up here because I think he misstated. And I think Judge Pan, you may have gotten to the bottom of this. He misstated what happened here. Captain Hight has never argued that he continued to take these trips during 2016 and 2017. His declaration was very clear. I was done in April 2016, right at the start of the 2016 season. His position was obviously I didn't have to do this. He never argues that he did take these trips, even though it's the right.
J107 says that, but it changes the years. That's the problem.
Well, it went backwards. I think they said 2017 and 2016 or whatever. But in any event, I think it was just I think the Heights Council just misspoke on that. He has never argued that. I think he said at some point, oh yeah, he took 12 trips in 2016 and 2017. And thinking about it, it really doesn't make much sense. You've got a 3-year training program. And the whole idea is you move forward, just like a junior associate, mid-level associate, you take on additional responsibility. The idea that, well, I just watch for a year and then I don't have to do anything for 2 years and then I get my registration to come on. Obviously that's not the way it works. It's not the way it's set out here, and it doesn't make any sense. You're supposed to continue to make these trips on the river in 2016 and 2017 so that you can continue to progress. And as government counsel said, the idea is as you get more experience, you start getting some hands-on experience.
The association explained to the Coast Guard, what opportunities he was given to do river trips.
Right.
He offered them in turn.
And we did.
I'm going to finish my comments. It's phrased like, oh, he made a choice.
Yeah.
He just wanted the money. He stayed over here.
Right.
But that requires evidence that he turned down and rejected additional training, which I did not see. It seemed to be sort of an unfair characterization if he wasn't offered the training. So is there evidence that he was offered the training? He said, no, I'm going to stay right here where I can earn money.
I don't know if that's specifically in there. I think Judge Pan was skeptical that the way this works is you just sit back and wait for them to give you the training.
That's not my question.
Yeah.
My question is, there was like, the way it was phrased was very negative towards him. Oh, he just wants to stay on the lake, on the lake and earn money.
Right.
And implying that he was not taking opportunities to do the river trip. So I'm going to ask my question again, since the association is the one that has this whole plan, supposedly knows how it operates. Is there any evidence in this record as to that he was offered the opportunity to get these trips?
Yeah, I'm sorry. I think I'd have to look to see if that, certainly, as you would expect, somebody who's in a training program has to take some responsibility for his own training. There's certainly no evidence.
I don't actually have any idea how this works. Right. Associates in firms, like, we put stuff in their inbox.
Right.
We don't expect them to go out in their first couple of years and find the cases themselves and come back and go, what do I do with this?
Right. But as they get to a mid-level, you want to see them taking some responsibility for their
Okay, but
cases, just
how
like we
does-
want to see them taking some responsibility
Okay.
for their training
So
here.
tell me how it works. Tell me how, and I assume this is written down somewhere in your documents, how it is that these folks get assigned. What if people just said, we don't like Mr. Hight, we're not going to give him any river trips?
Yeah, the point is, there's no evidence. I am not sure if there's evidence that he asked and was turned down. I think what he would need for his position was evidence that he took the initiative and was turned down. And there's no evidence.
You don't know how it works.
I know how it works.
Tell me how it works.
How it works. So how it works is you're dispatched onto the lake, but so there's a whole tour to roll and people take turns. And generally you're dispatched on the lake, but at some point in the course of those 2 years, you have to say, okay, I've got these dispatches on the lakes. I have to find somebody and get my lake training. And you have to take responsibility for looking at that. In other words,
You go find, so that everybody has to go find.
well, there's a
somebody.
training committee. There's a training committee and you know who they are. And you say, look, I'm supposed to continue my making trips to the designated waters. That's a requirement that he has, that he knows he has, and he has to take some responsibility for making that happen.
He writes a letter saying, please give me some river trips?
Yeah, there's nothing like that in the record. There's nothing in the
That's how it
record.
works in practice? You go to a committee, I'm just.
You go to the practice and yeah, I mean, yes, as it works in practice, you take some
the committee
responsibility.
runs this-
There is a
dispatch
training
service?
committee. There is a training
I know,
committee
but
and.
Do they have any control over the dispatches?
Well, see that, I mean, so the dispatching is, that you're on a roll and they take turns. You
Who's
get
they?
the people who run the dispatch committee. The people,
Dispatch committee is different than the training committee.
well, yes, that's right. The people who do the dispatchers,
Okay.
okay? They actually do that. But look.
What's the point of going to the training committee and saying, I need these things?
Yeah, I mean, the answer is you can say, okay, I've been dispatched. There are lots of requirements here too for,
I'm asking for a very direct
Yes.
answer to a
Okay.
very direct question.
okay,
All right. There is a person or persons in charge of dispatches.
right.
He needed river dispatches. You say he had to take initiative. And your first explanation was, we'll go to the committee, but the committee doesn't control dispatches. So what was he supposed to do to get dispatches on the river?
One thing you could do, I suppose, and look, I mean, you're a little bit outside. I don't do this day to day, so I don't really want to try to handle.
Well, the
But
association
there's
does
got to
this
be,
day in,
but
day
there's,
out. Client.
the answer, I'm sorry.
Your client does this day in and day out. It's their program.
Right,
So,
yes.
and this is an issue in this case. And so
Yeah.
how does he can't come and say, oh, he should have done something more, but no one can tell us what more he was supposed to do.
Well, you can tell the dispatch committee, I can't be dispatched because I have to go training. That would be one possibility. You could try to get
He
the
wants a
dispatch.
particular dispatch. He wants a dispatch for a river trip.
Right,
Is
so,
it correct that dispatches is for people who are going out to be the pilot? Like,
Right.
Be paid for it?
yeah, so if you're
So
dispatched,
He's only getting dispatched on the lake because he's.
Right, exactly.
Temporary membership for the
but-
lake.
yeah, and let me.
He's on the roll toward a
Right,
roll for the
Right,
lake.
exactly.
But if he wants to go on the river, he has
Yeah.
to go to the training committee and say, I need some time on the river. Can you arrange
He
that?
could do that. And he could also tell the dispatch committee, so let's just take a hypothetical here. Because my client does this day to day, I do not. But suppose the dispatch committee comes and says, or the dispatcher, I don't know if it's a committee, suppose the dispatch people come and say, we want to dispatch you on the lake. And you say, I'm sick. Okay, you have to find somebody else. And so they find somebody else. You can also come and say, okay, you're going to dispatch me. I need to do these river trips. Find somebody else to dispatch. I need to do my river trips. In other words, you can try to
That
work
doesn't
it.
get him river trips. That just gets him unemployed.
No, it doesn't get him.
Yes, because you said they're coming saying, go out on the lake. And he says, no, I have to get some river trips.
Correct. He could
They're
say
gonna
that.
Okay, you can't have this lake trip.
That's right. And that's exactly the point. The
But that
Coast Guard,
doesn't answer
How
How
does
you
he
get the river trip?
he gets the river trip because then he goes to the training committee and says, I now have a slot here. So his argument is basically,
And the
Um,
training, okay, here's-
I'm sorry, I'm sorry, we're talking past each
Can
other a
the
little bit. I'll just
training-
get slow down.
Can the training committee find who's going up the river today or tomorrow and say, thank you for coming and telling us that you needed experience going up the river. We
Right.
agree that you do, it's
Yeah.
required.
Yep,
We know that Captain Pan is going up the river tomorrow.
right.
You will go with her.
Yeah, exactly. And they could
That's
say,
how it works?
and they could say to the dispatch
They-
people,
I don't want could, I want to know, that's how it works. And so then Captain Pan has to take him along?
well, I mean, it would probably depend on the schedule, but let's back up a little bit here. He had 2 years to get this done, okay? At some point in the 2 years, he can go to the dispatch folks and say, look, I don't want to be dispatched here. I need to go on the river. Just as he could if he were sick or he had some other conflict. He could take some responsibility for doing this. It's a 20-person organization. They can talk to each other. Then, and you just work it out. You tell the dispatch people, I need to go on the river. You find somebody on the training committee to tell you on the river. You take some responsibility and you get it
I'm
done.
getting the sense that maybe you're not clear on how the river trips work. Because whenever we keep asking you for a direct answer as to how does it work, you go into sort of hypotheticals of things he's done. Because the thing is, there's a whole, I assume, class of deputy pilots who need river training. So there must
Right.
be some process for them to get the river training. But I'm getting the sense that you don't know what that process is, which is fine, but you should just say you don't know.
That's
You
what I
don't
was,
know.
that's what I was trying to say. I was trying to say, look, the way it must be in a small group is that you can take some responsibility for getting it done. The people can talk to each other, you can get it done. My only point is, there's no evidence in the record, as was pointed out earlier, that he ever tried to make that happen. The evidence is exactly what I think you were saying, Judge Pan, that his action is, well, I just sit back, there's nothing I can do and be dispatched. The point on the lake dispatch, and I think Judge Millett's question, you're getting right to what the Coast Guard is saying. The point of that is because, and I can't remember exactly if you either didn't get paid when you were taking these river training trips or you got paid it was either one or the other. You either didn't get paid or you got paid less when you took the river trip. So you were giving up some income by turning down the lake trip and taking the river trip to get your river training. And that was the point the Coast Guard was making. He does not have a financial incentive to do that. In other words,
Great
if,
financial incentive, he wants to get the full registration so he can get all the same work. I'm assuming, I could be wrong, that piloting up the river, given all its dangers and difficulties, may pay better in the long term. It's just like anybody else
Yeah.
who takes a little time off.
in
to
the
go to
long run,
school.
but if he
Well,
can.
We can't assume that he was driven, I mean, the way it was portrayed to us is he was driven by finances. We can't assume that at all.
Well, I mean, with all due respect, I think you can, because his position was, I've already done everything I'm supposed to do on the river. I took these 12 trips that ended in April 2016. I'm done. I don't have to do anything on the river. And then his counsel says, and by the way, there's nothing written down that says I have to, but there is something written down that said he had to. His position was he didn't have to. I'll go keep making money on the lake. I won't do this river training, and I'll get some counsel later to say I can be registered anyway.
Did the
That's what's going on in this
The
case.
association tell the Coast Guard, and where is it in the record, that he was wrong when he said, only after a pilot is fully registered is he allowed to pilot a ship on the river under an experienced pilot supervision. He said that to them. The association answer that.
I think what the association, and this kind of gets a little bit, the answer is, I don't know if we put that specifically in the record.
That seems pretty important. That seems to be his, that's his evidence that you don't require that we do all these trips again as a deputy.
I mean,
Who wants, this is you told us how dangerous this water is. Who wants somebody still in training doing the navigation?
With all due respect, there were so many things that Captain Hight threw into this record. If we overlooked addressing one specific thing to provide to the Coast Guard, maybe that's on us. But this gets to the point about just his say so. I mean, there is so much of.
Can you say he's wrong?
He is wrong, yes. Your question is, did we put this in the record that he's wrong? The answer is yes, he's wrong for the reasons I'm explaining. Anybody can take responsibility for complying with this written requirement that his counsel said didn't exist, but anybody can take responsibility for that. There's a way it can be worked out. Did we lay that out for the Coast Guard in the record? All these specific questions about what you do and all that. I'm not sure if we did. I'm not sure if we put that in the record. The point is, he has no evidence to the contrary.
I would have thought it would be, this is not a scattershot thing. I would have thought it would be core and elementary in saying he didn't meet the deputy pilot training program.
Right.
To show that we do let deputy pilots go out on the river piloting a ship under supervision. That's what so you can't just say we require it without saying, and it happens.
Yeah.
This was not a sort of one of those things that was, a general, something scattershot out here that he was arguing. This goes to the very core of the issue here.
Well,
Whether you say he doesn't have this training, he says, I can't get this training.
Yeah.
So why wouldn't that have been something?
Well, he can get the training. And look, if it's something that we didn't specifically put in the record in chapter and verse, it's
Chapter and
something.
verse, if you tell me, I don't need chapter and verse, give me something implicit.
Yeah. You know, I can't sit here and say that.
He says I can't, you say he can.
Yeah.
Neither's in the record. What are we supposed to do?
Well, I think it seems to me, we're going back to, I think, where we started here was a specific requirement in the training plan. He argued it isn't, it is. His position is that apparently that he didn't have any responsibility for completing this, that it was up to us to handle it and babysit him through the process. That's not our understanding. And if we didn't put that specific understanding in the record, that might have been an oversight on our part. He raised an awful lot of different points. I did want to get to Judge Wilkins' point, just as one last thing before I sit down, because now I'm over time. But the whole question about Baltimore Gas and Electric and what about these other people? I mean, I think I kind of see that kind of the way Judge Wilkins did, which is you do have a requirement here for undertaking these things. And if it's clear that you didn't fulfill this requirement that's right here on page 135, if it's clear you didn't undertake that requirement, you can point out, you can say, well, maybe other people didn't have to do that. There's no evidence here in the record, or allegations, that the agency actually looked at those other people and said, yes, we, the agency, are fully aware of all of this. We, the agency, have decided that it's okay for them and not okay for Captain Hight. And I think that's the difference between Baltimore Gas and Electric. In Baltimore Gas and Electric, the issue had actually been squarely presented to the agency. So we didn't have a situation where it's somebody just making, as you pointed out, an unsupported allegation that other people were treated differently. You actually had agency decisions that said, here's the set of facts with these other people. We're coming out differently in that case than we're coming out here. There's none of that in the record here. There's just the allegations. So
for registering these other pilots matters of public record?
And they're not matters of public record.
They're not matters of public record.
Yeah, I don't believe they are.
Well, then how's he supposed to know?
Well, he says he knows.
You can't just say the Coast Guard did it, but the Coast Guard's the only one that's holding the papers.
Right, that's his argument and the response to
You tell me that's reality. It's not just his argument. That's reality is what you just told me.
Well, no, because I think you pointed out one thing he can do is he can go talk to the other people that he's speculating about and say, hey, did you make the trips or didn't you make the trips? I mean, that was the point that you raised with my
I got my
counsel.
bar license without passing the exam. I don't want to find a declaration saying that in public. Who's going to want to say, no, I wasn't trained either?
Well,
Is that realistic?
I think it is. I think it's realistic that I think you try to come up with something, or at least you say, let's put it this way. If you talk to the person and he says, well, yeah, I mean, take this, for example. You talk to the person that says, yeah, this happened to me. You can put that out, but he doesn't really have, he doesn't really have that either. I think the answer is it's just you've got speculation, and does the agency have to run down every speculation? I think that's really the answer to it.
Any more questions?
Thank you.
Thank you very much, Council. All right. Let's see. Mr. Redfern, we'll give you 3 minutes.
Thank you, Your Honor. Quick point about Baltimore Gas. The court in Baltimore Gas specifically rejected the argument that this burden to explain inconsistent treatment doesn't apply if decisions are made by low-level employees or aren't contested. It could affect the weight that it puts on that prior precedent, but the burden of explanation is still there. These are agency decisions at issue. The decision to register a pilot is made by the Coast Guard, and the Coast Guard is supposed to be receiving these pilot training records to confirm that it's done. So those are Coast Guard decisions. The only burden that we're asking for here, this is not to do a sprawling investigation. We're just talking about evidence that is under the agency's control. I think that's a pretty limited burden here when we have such specific allegations.
You understand that we see a lot of agency cases and saying, look at the records you have under your control. It's not a small ask.
Well, this is a pretty small ask because he identified
So
pilots.
we don't have a small ask rule.
Well, Your Honor, I think that goes into the reasonableness of agency decision-making. If you have this kind of a contested issue and the burden is very small and the party is just pointing you to it, he says, look at those 10 people, it should be in your records. I just don't think we could say it's
The 10
reasonable.
people weren't as to the critical argument here. The 10 people were as to the minimum trips and then getting to take the exam, or what, I don't know if it was even 10 people, but
That-
here, you just have a flat assertion that you can't do the trips you want me to do until you're fully registered. It's just a sentence?
Well,
Single
no,
sentence?
Your Honor,
Reference
so
to
this is not just about the minimum trips. There was a lot of back and forth between my client and the Coast Guard. Say,
Where on the record does he list people?
JA 208, and this is where the Coast Guard is saying, you seem to have not completed your training. And he says, I've done all the training. I did the same training as these other pilots. Look at their records. So he didn't yet know that this was going to be even about the minimum trips requirement. And throughout this back and forth, where the Coast Guard was saying, well, the association says you haven't done your training, he said, I don't know what training I haven't done. They say, take it up with the Coast Guard. And he said, or sorry, take it up with the association. And he said, they,
208 about exam pilot training.
Or sorry.
Exam, we're not talking about the exam now.
188. Well, so he was trying, to be clear, Your Honor, he wanted to take the exam and they were saying you can't take the exam because you haven't
Now we're
completed your
talking
training.
about a different thing. Now we're talking about his separate allegation, which comes paragraphs after his talk about who got to take the exam stuff on paragraph 98, which is just a flat sentence. Only after pilot was fully registered was he allowed to pilot a ship on the river under an experienced pilot supervision. That's what the issue, that was a basis for the Coast Guard's decision. That's what the issue is here. You said he couldn't, but there's no, he doesn't say, ask so-and-so. He doesn't name anybody.
Your Honor, in a JA 188 and 208, he identifies the specific pilot numbers. He says, I'm being treated differently. Now, at this point, I agree that he didn't know.
188 is still about the written exam.
Right.
Okay, I'm asking you for evidence that he was treated differently and that
So,
documenting that nobody that he knew was given full registration, not taking an exam, was given full registration without having done even a single trip on the St. Lawrence.
Your Honor, it's the same issue because in Hight 1, what the Coast Guard said was you can't take the exam because you haven't completed your training. So he won, he got to take the exam. Now they're saying you can't get registered because you haven't completed your training. And in Hight 1, in all that back and forth with the Coast Guard, he was saying, I've done all the same training as everyone else. I've completed it. Just look at their records.
No,
So
it's a different allegation to say that you can't do, no, because his argument there was, I've done these as an applicant, where he talks about, by the way, as an applicant, you go to sleep while the pilot takes it through the river.
He
So,
said that
I know
others
that-
have, Your Honor. He did not say that he did.
That's what it says. It's not helpful to him. It doesn't show he's had any real training at all. This is a different point. Well, this is about mechanics, about when, this is a different factual assertions. How can I get these trips in?
Right.
And that was not what happened before.
So
He doesn't say, I know anybody who was able to get these trips. I don't
So,
know.
Your Honor,
He was not able to get them until after they were fully registered.
JA 189 is where he one of the places where he tells the Coast Guard that the association won't talk to me. So the Coast Guard
That's
kept,
not evidence of how other people were treated.
well, Your Honor, though, the Coast Guard was saying you have to talk to them to find out what you need to do. He was saying, I don't know what I need to do. I've done everything I was supposed to do. And they say, talk to them. And he says, they won't talk to me. So how is he supposed to find out what it is that he hasn't done?
Okay. Well, then why is he making assertions? Why is he saying, I know how this works, if he doesn't have anybody who told him this is how it works?
Because, well, he was saying that I did the same thing that all of my colleagues did.
Okay, then get statements from your colleagues saying, I got full registration before I did any trips solo piloting under supervision on the St. Lawrence River.
Well,
Easy.
as Your Honor noted, it's
Easy.
not, two things, it's not necessarily easy. And at no point did the Coast Guard,
Do them under John Doe, submit them on camera.
the Coast Guard never said that there was insufficient evidence, show as proof. They just said, we're not going to talk about it and we aren't going to address it. Now, I think that this fact that he's consistently told the Coast Guard that I can't get an answer from them, I think that really undermines this notion that he knew what he was supposed to do and that this was all public. He's saying, he's representing, I did what I was supposed to do, I did what I was told and what everyone else did. Coast Guard says, we're not sure what you have or haven't done, take it up with the association. And he tells them the association won't talk to me. how is he supposed to get these trips? How is he supposed to even find out what it is that they think he didn't do? And also to the plausibility point, does it make any sense to think that this small organization, if this was in fact a requirement, had no idea that he hadn't done something that was supposedly required? That he'd been doing this for 2 years, he's on the verge of getting added to this group, and then they come up with this at the 11th hour after they've already decided that they're going to blackball him. And then finally, just to the full versus lake registration issue, because there was some skepticism about that earlier, Judge Pan. I think JA 130 is probably the best answer to that. This is where my client gets his temporary registration. It just says he's temporarily registered, and then he will be added to the tour de role for the lake. And that's how this worked. That they weren't saying you get a full registration for one and then you go back to the Coast Guard for another. It was that the association, through its dispatchers, was only sending people where they had completed their training. And that's all he wanted in this case, was to get full registration to pilot ships the way he had been doing over 100 times, and to do it on the lake.
Thank you very much.
Thank you.
Both counsel, we kept you up a long time. The case is submitted.
Stand, please. This honorable court now stands adjourned until Friday, November 1st at 9:30 a.m.